Well, may I have the liberty to mention this matter? Mr. Shurujit Nath Mitra was doing it yesterday, order 13A. Lordship,
Yes.
my lord, directed to this matter to appear as a specially fixed matter today.
Today, yes.
My lord, I think there's some error, my lord, it's not listed today. May a supplementary list be published, my lord? I can come at 2 p.m., my lord.
I'm for the respondent, my lord.
2 p.m.
My lord, it will be taken up at 2 p.m.
কিন্তু একটা না দিয়ে দিলে তো বুঝতে হবে 2 p.m. করে দিই।
Grateful.
Yeah, I permit to mention, Lordship, the learned court fixed the matter on 12 August. Earlier occasion, I mentioned the matter, your Lordship, is to opine that to file an application. We have filed the application, Lordship, 12 August is the date fixed before the learned.
And about the slip.
May I permit to mention one matter, my lord? Your Lordship, 20th June 2025, your Lordship make it not CAB, my lord, but interim order expired yesterday, my lord.
Interim order expired yesterday.
Yes, my lord.
ওটা একটু কালকে এক্সটেনশনে দিয়ে দেবেন।
আমার একটা মেনশন স্লিপ আছে স্যার, খুব আর্জেন্ট আছে।
দিয়ে দিন।
7 তারিখে লাস্ট করে ডেট আছে।
Yes, call the list.
দেখবেন
ওয়ানটা 12টার সময়।
Well, this is my application for extension of interim order,
Yes.
Can 4. Lord, the affidavit of service may be taken.
My lord, the matter arises out of a probate proceeding, which has been converted into a suit, lordship. The executor is my client. He's about 70 years old. The other executor has passed away. He's the only sole surviving executor. Lordship will only fix a date where the matter can be heard out.
The impugned order.
Lordship. No.
What is the impugned order?
Lordship.
The impugned order is that, my lord, I filed an application for recalling of witness because the witness was not complete. So that order was rejected by the learned judge. Against that, my lord, I have filed this revisional
Filed
application.
an application under order 18/17,
Well,
which was rejected, lordship. It was their contention that they had
It's a
not
small matter, your lord, you can fix the matter for hearing.
any.
Any date, and in case the matter
It will take only 5 minutes, my lord. Only 5 minutes, lordship.
Where is your application under order 18 rule 17?
In the main application, my lord, annexer P6, page number 38.
Lordship will kindly peruse paragraph number 13 at page 40. That is the main prayer. And that is the reason they want a recalling.
It's a very limited issue. The person died out of cancer regarding the will, and
No, why you wanted to recall? For what purpose?
my lord, the witness of the concerned doctor and the hospital personnel is absolutely important, my lord. It's
No,
psychoanalysis.
this is order 18 rule 17 is to recall the witness who have already deposed. How can it be who have
No,
not deposed?
it was asked to the witness that whether she wants to add any witness or not.
Yes.
Somehow she said no.
Yes.
Due to certain reason and certain
Did you file the
circumstances.
list of witnesses?
No, my lord.
No, list of
Then-
witness was not filed in
then-
that court. But thereafter, my lord,
This is only to delay the entire proceeding, my lord, in my humble submission. And order 18/17 does not confer that right upon the litigant. It is only for
only
the
that
it is
you
power
may kindly fix the matter for hearing. I will satisfy your lordship.
Order 18 rule 17 may not be there, but
But
151
they
is
have not
there.
submitted any list, and on that day they did not mention anything that she was
Satisfy
witnessing
your
not
lordship on
failing.
the date
No
of
ground
hearing.
has been stated in the application.
No, bro.
Nothing. Ashok. Though this application is a
Your Lordship, in this matter, I appear for the applicant, Your Lordship.
Yes.
But the only thing is, my lord, no copy of the application for extension has been served upon
Your
us.
Lordship, the interim order expired yesterday. The matter was listed yesterday.
You filed any application?
No, Your Lordship.
Yesterday it has ex. What is the
Because
necessity
of
of
the
filing
resolution,
application? Is
Your
the task? Interim order, civil division application is pending. And it's within time they have mentioned yesterday we are not there for that. Then after hearing the learned advocates for the respective parties, the
But I'm for the petition.
yes,
For the opposite party. No prior notice of mentioning has been served.
I've not
No
been,
prior-
I have not been intimated that he is appearing. I have served
Matlab-
twice.
did you serve notice upon him?
They can serve upon the client because no advocate is appearing.
Sir, when did you enter appearance?
So yesterday.
When did you file vakalatnama?
Yesterday.
Yesterday. When did you come to know who is the learned advocate for the petitioner?
Yesterday itself because
So, did you communicate to the learned advocate for the petitioner that you have entered appearance?
because prior notice of mentioning has to be served upon the client.
Since you have
Matlab-
entered appearance yesterday, yes, I'm explaining.
it is only regarding 7-1.
Yes.
They have deposited the
Only one thing,
they
the
filed an application after the time.
Honorable Supreme Court in the matter of lordship, where the Devashish and the others are considered.
Not considered
24th
because it is
because
also
judgment
two
is
judge
up.
bench.
The
It is
bowling-
also two judge bench, my lord.
Can one, what is can one?
No, it's filed yesterday only for extension because it has
That
expired
application has
yesterday.
also not been served.
It is expired
Sir,
yesterday.
give a copy.
Yes, I'm
After here, can one of 2025, this is an application for extension of interim order. So after hearing the
Well, first an interim order for the stay of the suit. And during the continuance of that interim order, I filed this application for the extension of the interim order.
Yes,
Today only I have received the brief pilot. Today only I have received the brief pilot.
could not solve. Please use the mic.
Today only I have received the brief pilot. Your lordship can extend the
Yes,
interim order.
Can 1 of 2025, this is an application for extension of interim order. After hearing the yes,
7, my lord, this is my application.
yes,
My lord, Justice Rajabasu Chaudhary, last occasion directed to serve upon the learned advocate appearing for the respondent opposite party number 6 in the court below, my lord. I have served, my lord.
yes. What is
Interim
the
order,
matter?
my lord,
What is the impugned order?
Order 6, Rule 17 application has been rejected by the trial court. Against that, I have come up before your lordship, my lord. On the ground that plaintiff is trying
It
to
has been
fill up the
rejected.
lacuna. Rejected, my lord. Plaintiff is the petitioner before your
Uh,
lordship.
Every service filed in court today is taken on record.
My lord, it is
Next, call the next matter.
8.
Item number 8 with K.
8 with 9.
8 and 9, yes.
My lord, I am this is my application for extension of interim order. 8 and 9 are tagged together. 8, I am the petitioner, and in 9, I am the opposite party. Both parties have come before this honorable court against the impugned order dated 10 September 2024, passed by the 14 learned 14.
What is the nature of the order?
Occupational charge
passed in a appeal court, my lord. The tribunal, learned court below has granted 10,000 in Bagajotin area from the date of the order itself. I have preferred a revision as an application, varying from the date of the decree and enhancement of this amount. That was
What is the suit property? What is the suit property?
they are we have obtained the suit property by virtue of a we have obtained the suit property.
What is the extent of the suit property? Commercial purpose? or
Residential 630 square feet over the road, main road.
My lord, the original defendant and original plaintiff are brother and sister. There is no relationship of a licensor and licensee between the parties. They are the judgment, the decree holder. We were the judgment debtor in the before the
What is the suit for?
Eviction of trespasser.
Declaration.
It's my suit, my lord.
Show me the decree. So you have preferred a title appeal?
Yes.
I have, my lord, I have preferred a title appeal against the judgment and decree, and in the title appeal there was a limited period of stay without an occupational charge. My lord, against that they came before
so according to you, no occupation charges could have been imposed.
My lord, that is one of my grounds, because the original defendant and the original plaintiff are brother and sister, and it is my case, my lord, that I was the person, because I was the elder sister. This all happened. RRRT is a party in the original suit as.
Who is the owner of the property?
My lord, no one is an owner of the property because.
Who is the owner of the? Show me the decree, madam. You have suffered a decree appeal. Stay. You have to
and my lord,
take occupation charges.
My lord, I have already paid 50. My lord, I have already paid because if my lord takes a look at the order of the coordinate bench on 7th February 2025, which granted stay, there was a direction to pay 50,000 upfront, and that has already been paid, which is
There was a direction to pay.
on in the order dated 7/2/2025, which granted stay, my lord, and they also wanted a stay because they have also come
I
against
have
the
not
same
paid
order.
stay. We have paid for
50,000 you have paid.
You have
Yes.
paid for the stay, my lord. I can.
No, you have paid
Yes, yes, my lord.
50,000. So that was a lump sum amount. Now the quantum has to be fixed. Show me the order of the appellate court.
My lord, the order of the appellate court is
kindly comes to page 112.
Yes. Or madam, one thing can be done, let the execution proceed. You need not pay anything. If you succeed in the appeal, you get the property.
my lord. How my lord must appreciate that there is.
There are two things. One is if you want to obtain a stay, you have to deposit occupation charge.
Considered that.
That is a ad interim, subject to the condition. It was directed. It's not the final consideration.
My lord, may I?
50,000 will be adjusted. Whatever it is being adjudicated, 50,000, whatever you have paid, will be adjusted with the quantum of occupation charges that will be
May
decided.
lord kindly appreciate.
There are two things. If you do not want to pay occupation charges, do not pay. The execution case will proceed. If you succeed in the appeal, you
My
get
lord,
back the property.
there was an undertaking given by the my learned counsel, my learned friend, that they would not proceed with them. This is all part of the 7/2/2025's order. This is recorded that they will not 6/12/7.
Now, madam, it has come up for final hearing. Please make your submissions.
My lord,
If you are ready, you can make your submissions. If you want another time, I can give you.
my lord,
But,
may I make a because there are certain submissions, and I need to place judgments, and I need to place my submissions, and I think I have a very strong ground of succeeding.
Show me
in
the
appeal.
judgment.
My
Show
lord,
me the judgment.
that's what my
On what
submission.
point?
My lord, on the point that there cannot be a relationship of a licensor and licensee within in intra-family member. That is one, my lord. And I have my lord, because today I do not have the copy of the evidence from the trial court, and I would have demonstrated.
Madam, I will not go through the evidence
My
at
lord,
this stage.
of course, my lord.
So I will go because you have suffered a decree. You want stay. So I am not deciding the appeal. I will only consider whether you are liable to pay occupation charges and what should be the quantum. Only that much, nothing more.
My lord, for determining the quantum, may I suggest, my lord, I'm just trying to assist your lordship, that in that event, my lord may extend this interim order for maybe a few weeks or maybe a month, and let this be placed for hearing, because my lord, the two
One thing can be, what is the stage of the appeal?
hearing is continuing.
No.
My lord.
Hearing will start from the August 4th.
4th of August.
It will start because they were not effecting proper service upon the.
All right, from 4th of August.
I am being told that the hearing will start from 4th.
I am directing the appeal to be disposed of.
My lord.
My lord, this is the.
I am
hearing is
directing the appeal
continuing.
to be disposed of within August.
My lord.
Yes, my lord.
And pay some amount. And what is the execution case? What is the date in the execution
The
case?
execution has been stayed since the state to disposal since there was a direction from the other coordinate bench that we will not proceed since they have deposited a sum of 50,000 consolidated for the time being.
Yes.
For that which we are not proceeding with the execution.
I am directing the appeal to be disposed of.
My lord. My lord.
Yes, my lord. I have no.
Of August, it is the next
Yes,
date
yes.
fixed. Ashok. This application under Article 227 of the Constitution.
was that license is not an inheritable right.
Madam, in a better case, I will consider that. Not in this. Next.
Item number 10.
May I please, Your Lordship, my lord, I am for the petitioner, Your Lordship. My lord, pursuant to Lordship direction, we served the Lordship. Yesterday, the identity model expired. It was extended till end of July.
They have received.
Yes, Your Lordship. Served all,
When they have received.
long back, Your Lordship. My lord, received it on, I'm telling you, Your Lordship. April, in the month of April.
Every service filed in court today is taken on record in
Number 11.
In this
Published.
matter, I am appearing on behalf of the plaintiff landlord opposite party matter. Your lordship directed me to find the total plaint. And your objection was that the all annexure of the plaint was not supplied. Though plaint is annexed here. Plaint is annexed in the revision application.
yes, the other
It was readily available to the chamber of the Raleigh advocate. But one of the annexure matter only legal licensing agreement. Is here.
that was annexed. Hand over the copy.
Thank you. That was my lordship.
Yes, now you have got
Another answer is not given. Another answer is not given. Answer A was not given.
annexure A.
My lord, annexure A. Let me ask you. Deed. Registered deed of. But
Yes, why are you not giving Mr. Vadajaji?
actually, it was not really at the time of your shaft. After
Mr. Vadajaji, then it will be delayed. I am extending the order.
Your lordship directed to your lordship on that day you should ready the file to detailed statement. Your lordship directed to
Mr. Vadajaji, they say that you have not annexed this. I asked you to give these documents. You are taking coming up in piecemeal. What can be done?
He eviction suit. Your lordship direct the land senior division to try to give an opportunity to file the detailed statement. And after this being
You will again take this plea. Documents are not there.
speak the document. After receiving the document,
Mr. Vadajaji, why are you not giving the documents here?
only
That will be shorten this procedure. Otherwise, they will go there and say, no, it has not been done. You will not serve. They will also not file.
member of the land plaint is not readily available.
What can be done? When can you serve?
Using 2 weeks.
Why 2 weeks? Can you not bring in the next week?
Actually, my lord.
Then I am extending the interim order. Then I am extending the interim order. I gave you chance. After hearing the learned advocates for the respective parties. You have filed that application for extension. ক্যানটা ডিসপোজড অফ করে দেবেন, বুঝলেন? ক্যানটাকে ডিসপোজ, ক্যানটা মধ্যে এক্সটেনশন দেখে দিয়ে ডিসপোজ অফ করে দেবেন। Yes.
Would I appear for the opposite party, my lord? I'm led by Mr. Promit Roy, my lord. He's appearing virtually.
Yes, Mr. Roy.
My lord, this is.
Yes.
Milord, passed in an execution proceeding, Milord, directing execution
Mr.
of
Banerjee, what papers you have annexed here?
Yes.
What are the
Milord, some
documents?
documents are missed out. Some
documents
are missed out.
Thank you. Your learned advocate on record that he has missed some documents.
But Milord, it should have been, Milord, segregated in 2-3 volumes. Milord, ought not to have been. There was. My lord, arbitration award. My lord, we challenge under section 34. My lord, section 36 application was also filed, which was prior in time. My lord, subsequently, my lord, a second section 36 application, my lord, because of inadvertence, my lord, was filed in
Was
about.
prior in time, meaning I could not
I tell
follow.
your lordship, my lord, they put the award into execution.
Yes.
Before, my lord, the execution application was filed, my lord, there was a section 36 for stay of operation of the award, my lord, that application was pending. My lord, what my lord, the learned commercial court did, my lord, by passing the impugned order, when the learned commercial court has allowed the execution application, keeping my lord by section 34 pending, I can understand. But my lord, keeping my application for stay of operation of the award also pending. Now, my lord, in the execution application, my lord, while opposing the contesting the execution application, we took, my lord, several points. That, my lord, why, my lord, this arbitral award, my lord, cannot be put to execution. My lord, I'll, my lord, shortly, my lord, briefly indicate, my lord, the reasons before your lordship today. My lord, the learned court below, my lord, was of the view, since there is an award, nothing doing, you have to do this. Now, my lord, the award was for specific performance of contracts. 3 or 4 contracts. Out of them, my lord, only one contract had an arbitration clause in it. My lord, there was no specific reference to the arbitration clause contained in this one contract, my lord, in the other contracts. What learned arbitrator did, learned arbitrator, my lord, directed by passing the award, directed specific performance of all the agreements, irrespective of whether there was an arbitration clause, my lord, incorporated in the other contracts or not. And my lord, the doctrine of incorporation of arbitration clause by specific reference, my lord, that
Mr. Banerjee, those are points in section 34.
also in 36. Also in 36.
What is the scope in 36?
Yes, my lord. Boi.
Arbitration Act, ঠিক আছে. Yes.
Madam, a little handicapped today, my lord. I was not told that the matter would appear. And the book is not with me.
The stated papers shown that it will appear today.
তো বই আছে, বই এনেছিস? Thank you so much.
But this application 36, according to you, is pending.
Still pending. But the next date is on, my lord, August, middle of August.
Yes, Mr. Rai, this section 37 has to be considered.
And that was prior in time. My lord, my learned senior friend.
My lord, this is, with all humility, I submit, my lord, this is an incorrect statement. First thing, kindly see that when we moved the execution application, my lord, they were, after the award was passed, my lord, they were implementing the award. Suddenly they stopped. In fact, my lord, from page 574, my lord will find that in February this year, they have issued a public notice that they will not do anything. Then, my lord, we moved the execution application. After the execution application was moved, copy served, they took out the stay application. My lord, I mark my words. And they have admitted this at page 421. Kindly see,
Stay application disposed of, Mr. Rai, stay application disposed of.
No, my lord, I submit one thing. My lord, stay application was not disposed of. Why? Because of them. My learned friend said stay application was filed earlier. My lord, why this is an incorrect submission, I say. The stay application was filed after the execution application was filed. They themselves in the stay application say that don't proceed with the execution application. So if the stay application was filed earlier, they could not have said that they don't proceed with the execution
Mr.
application.
Rai, what is the date fixed for hearing of the stay application?
30th of August, my lord, because the judge, the 30th of August on their prayer.
Mr. Rai, I am directing the section 36 application to be disposed of.
Deeply obliged, my lord. Deeply obliged. They withdraw. They wanted to withdraw this stay application because they say hearing is concluded. Let hear the main application.
Now
Mr. Banerjee was there.
Mr. Rai, since it is fixed on 30th of August, I am directing the section 36 to be taken up and decided. Till then, don't proceed with the execution.
No,
Otherwise,
my lord, no, my lord, no. Why not? Why not?
Mr. Rai, otherwise it will become infructuous.
No, it has to become infructuous in this sense. My lord, may I just argue this? Kindly keep it next week, my lord. I will argue this point. Why? My lord, today they cannot eat the cake. Well, I have moved the execution application first. Kindly see.
No,
And
Mr. Mr. Rai, only one thing. The award is under challenge, section 34 is pending.
No, my lord, kindly see why I'm saying. They said settlement was done. We were proceeding with the settlement. Lots of things has to be said.
No,
My lord,
section
this is
34
not
is
a
not pending. Mr.
No,
Section 34 pending or not pending?
pending, but pending for the simple reason to be resolved with consent, not for stoppage of execution. Today, if the execution is stopped, everything will come. My lord, let me have the.
Mr. Rai, let us accept for the moment your submission that the execution will proceed. And if the execution is disposed of prior to 30th of August, what remains?
No, what remains?
Nothing remains in section 34. Nothing remains in section 36.
No, my lord, no. Kindly see. Today, my lord, kindly see for once. My lord, kindly keep it, my lord. Next Tuesday or Wednesday, I will come and argue this matter, my lord. Then kindly pass an order. Because today my learned friend has not even annexed all the papers. I need these papers. What remains, I will show. My lord, it's a project of what? It is not a one building. It's a project, my lord, of more than acres and acres of land. Now, third part, we were executing the buildings and they were supposed to give the registration. They were giving the registration. We have sold on their behalf. Now they say, my lord, that they wanted some money from us. That's why they are not executing the deeds in favor of third parties. Court said, what is the money due? They could not present the document in respect of the registration deeds. These are flats, my lord. What will remain is this. An acre of 100, more than 100 acres is being built. 75 has been built. If the award is set aside, then also, my lord, 25 acres will not be built. But 75 acres which we have built, which third-party interest is being created, they are not executing the lease deed. That's the only thing. My lord, kindly keep it up on Wednesday, my lord. I will convince my lord that so far as what has been done should not be undone because of them.
Do you want?
Any day, that is convenient to your lordship, my learned senior friend, I do not have any difficulty.
Kindly next Wednesday, Thursday, whenever it's possible. But I have to convince my lord. And kindly give us leave to file a supplementary affidavit because execution application was also not placed before my lord in its entirety.
My learned senior friend is, supposed to move a perjury application in this matter.
Yes, they have committed perjury. They have committed perjury, which is pending.
But I cannot match my learned senior friend's voice.
Not that, my lord. This is
indicating, accepting 7th any other day.
Sixth possible, my lord, 6th or 8th.
করবেন কাল তো ফাঁকা থাকবে কোর্ট
Tomorrow my court is packed.
Tomorrow even?
Tomorrow no further time. কবে হবে? 8 তারিখ?
6th or 7th possible?
8th at 4 p.m.
This way till 6 o'clock, my lord. Then if my lord is keeping it at 4, very
not in the morning.
Great.
Great. List this matter on 8th of August at 4 p.m. Yes.
Till such time granted to file a supplementary affidavit as paid for by learned senior.
The opposite parties will be at liberty to file
8th, my lord, is some difficulty if it is on 6th, my lord.
6th is not possible. 8th is the only date, then September.
Not the 6th, there is some difficulty. 8th, there is some difficulty.
That is why I have checked up, no date. Then September. August, not possible. 8th is the only date. 7, 6, other things filled up. 8th, yes. As paid for by Mr. Rai, Learned Senior Advocate for the opposite party. The opposite parties will be at liberty to file an affidavit to the. You have not filed any affidavit, so no question of supplement.
No, first time, my lord, after 3 months, they have moved.
Annexing the documents which were annexing only the documents which were part of the proceedings before the arbitral tribunal or the commercial court.
Deeply obliged.
Yes.
Grateful.
But Mr. Rai, ask your advocate on record to make it a thinner one, not as thick.
Certainly, my lord. Certainly. Goes without saying.
But I was
Because
indicating
the
I have
volume,
missed out some
from this
documents.
volume, after that, even after that, Mr. Banerjee says some important documents have been left
Yes,
out.
yes, they have, my lord, because they wanted to say something which without which they could not proceed.
I do not know what is the purpose of making that voluminous revision application.
Because my lord, only thing, my lord, without going into just a stay, because the short point.
Call the next matter.
Deep levels.
May please, Lasamalade, dependent numbers 2, 3 and 4 of the petitioners before a lordship, and a suit for declaration and
No caveat is there.
no caveat is there.
Yes.
And cancellation of the deed executed by the opposite party, registered deed.
You are the plaintiff.
I am the defendant.
You are the defendant. Suit is for cancellation of a registered deed executed in favor of the defendant.
In favor of the defendant number 1, who subsequently transferred the property to me.
So you are the defendant number 2.
2, 3 and 4.
All right.
Now, my lord, the suit was filed and injunction was sought for, injunction was not granted. Now, my lord, without my lord producing any documents in evidence, because my lord, the issues has not been framed. Now, my lord, an application for handwriting expert for comparison of the document with the other documents that has been my lord, filed. The
that document has not been produced in evidence?
No.
Show me the impugned order.
Now, my lord, kindly see the order impugned, my lord. Issues have also not been framed. Now, kindly see the order impugned. The learned judge.
Mr. Learned senior advocate appearing for the petition and agreed by this.
My lord.
So that's the thing, because it's not connected directly at this stage.
Yes.
So
now, the next matter is also same. The
same order next. Why 2 suits?
The 2 suits.
Husband.
Abhi aste. Contested application after 12 weeks. Next is another suit.
Yes, by the wife.
Same order.
Husband, yes.
Same order.
Order date
তো suit number গুলো দেখে নেন।
না, সেটা ঠিক আছে। এটা
number
it's different.
Order number ডেটটা বোধহয় ডিফারেন্ট আছে, দেখে নেবেন। আমি তো ওইটা বলি, স্টে অফ অপারেশন অফ দ্য ইমপিউগড অর্ডার। Your prayer is correct.
Yes.
Please check up.
Yes.
The stay of
Prayer
operation.
is correct.
Yes, next.
Item number 15.
Yes, Mr.
My lord, this is arising out of land acquisition case, my lord. What happened, my lord? If your lordship pay to a turn to, my lord, page 20.
20. Yes.
There were, my lord, 2 properties. One is LRA 62. That was in the name of my father. I mean, it was in favor of my grandfather as a benamdar. My father got it, and she had 2 sisters also. They gave no objection. Now, this was the award passed in the judgment. Thereafter, state preferred an appeal. This Honorable High Court. In both the matter, we filed cross objection. Appeal was dismissed. Cross objection was allowed. at that stage in 2023. We've also filed two execution case. There's money execution, LA money execution, that is 1 and 2. Now, in the year 2024, somebody claiming to be the my lord legal heirs of my aunt in respect of first case also, but second was in the name of my mother. There cannot be any, they cannot have any stake. Now they filed section 47, where that award, which has been merged with the appeal court judgment, filed an application under section 47. Not in the execution case.
So what happened? Section 47 is pending.
That is, and I have been injuncted. Well, kindly, this is the most funny thing.
Injuncted from
withdrawing any amount from
Mr. Mukherjee, rightly or wrongly, what is the stage of the section 47? Section 47 has to be,
47, they say that
I'm directing the executive court to dispose of the section 47. Otherwise,
no, my lord,
it will become infractions, Mr. Mukherjee.
Because what, my lord,
Mr. Mukherjee, let it be disposed of. If it is dismissed, we will be at liberty to take back the money. Otherwise, it will be a difficulty.
Well,
keeping that, Mr. Mukherjee, otherwise the section 47 will become infractions.
There are two cases. One is in the name of my mother.
In the other, there is also section 47.
No, only one. For the two cases, can it be done?
No,
kindly see the application.
At that point, I'm directing the section 47 to be disposed of. Take all points there.
Time bomb. Well, can this in this award case, can section 47 be filed?
Mr. Mukherjee, I cannot say that, or I have to call them, issue notice. It will be kept pending here. Or in the other way, I'm directing the section 47 to be disposed of. Take all points there.
Well, it will be better.
That is why I'm telling you.
Well, because I want my lord,
but I cannot dispose of section 47.
No, your lordship stay, because this is in the wrong forum in one case. For both the case, can it be?
Mr. Mukherjee, take that point.
We have taken point. Court has said.
So what is the next date fixed for hearing of
August? Court said
I'm directing
you bring stay, otherwise I will direct them to pay to collect injunction.
I'm directing to take up the hearing of the section 47 on 14th of August.
Including mental ability.
Yes, all. This application under
My application. This is where my recalling application, when I went before the learned court below, has been rejected. My short point would be to direct the learned court below to take up the recalling application. My lord. He's been rejected on the ground that I have not served on the advocate. My lord, we went to serve on the advocate on the trial court. He did not take it. I served it on the lawyer appearing in High Court.
Mr. Ghosh, what do you say?
My lord, there is one.
You have got the recalling application.
Lord, your lordship,
Bosun.
Lord,
You have
kindly-
got the recalling application.
Yes.
Yes, I served it on the 20th
Your lordship,
only.
my lord, kindly see the last order, impugned order, and my lord's order. Two orders, your lordship, kindly see.
Yes.
My lord, the earlier revisional application was withdrawn. And we considered that if they make an application for recalling, we shall not. But your lordship mandatory direction was that it should be given prior to moving it with a put-up petition. They didn't give it. Thereafter, the learned court below, considering your lordship
Filing was not allowed.
Banerjee, let Mr. Ghosh make his submissions. He will be
My lord,
getting your time.
in terms of your lordship's direction, he went through your lordship's order and found that they have not complied with that. Thereafter, he didn't entertain that application. Subsequently, another application was made for recalling that day's order, 23rd July 2025, and also that earlier order, which your lordship directed. My lord, there your lordship kindly see the order passed by my lord and the
yes page.
My lord, your lordship's order
20
is at page.
Your lordship's order is at page 73.
Yes. 59 also, my lord. Page 59.
No, 73.
My lord's order.
73 is the lordship's order of 18th of July, where I was given the liberty to go
Yes.
file the recalling.
Lord 73.
My learned friend probably wants to, my learned senior friend probably wants to my lord, invite your lordship's order at page 76. Last paragraph.
73, yes, Mr. Ghosh. 73.
My lord, your
Which
lordship-
paragraph?
Last paragraph, page 76. So
76.
76 is last paragraph.
Yes.
Eight.
Yes. Lord, kindly see this. Last paragraph 76, it starts. In the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands dismissed as withdrawn, with liberty to the petitioner to file an appropriate application before the learned trial judge, if such application is filed on or before 23rd July 2025, along with a put-up petition after serving a copy of the same to the learned advocate on record of the opposite party herein, representing them before the learned trial judge. The opposite party herein would be at liberty to file written objection on or before 4th August 2025, after serving a copy of the same to the learned advocate for the petitioner before the learned trial judge. If such application is filed by the petitioner within the time limit indicated herein above, the learned additional district judge, 5th court at Howrah, is requested to take up the hearing of such application on 6th August and dispose of the same prior to taking up the application filed by the opposite party hearing.
So 6th of August is the next date fixed.
Next date was my lord fixed it. Lord,
No, I think it was said that that was the date fixed. That is why I directed that.
Lord, for contempt application. Contempt application.
Yes, that is
Lord,
why.
till today, since initiation of the proceeding, not a single order has been complied with by them. Not a single order. Flouting each and every order. Lord, they out of their own proposal, 28th and 29th was fixed for visitation. We gave notice that we are going to Bombay. They have not responded. They proposed that as yet not a single day, Lord, since the 21, we have not get any opportunity to visit the child. Every order, I will show from the order sheet that each and every order has been flouted. Even my lord's order also. It is their conduct.
Mr. Banerjee, why did you not serve it before moving that?
My lord, I went and tried to serve it. I have disclosed call records. My lord, kindly have a look at what is happening. My lord, no, my lord, I'll tell your lordship. Your lordship has seen the order.
Difficult to believe that a learned advocate will not accept.
No, so my lord, we went, tried to serve it. He did not take it. I come and serve it on the learned advocate appearing here.
Lord,
learned advocate,
that is not correct.
learned advocate on record, and then I file it.
When a proceeding is disposed of here,
in terms of a particular direction is given,
whatever it might be, if a proceeding is disposed of before the High Court, can an advocate, does an advocate who was empowered to represent a client in that proceeding have authority to accept anything? What are you saying?
We went there.
Neither you are not.
No, we went there, tried to serve it on the learned advocate on record.
That's a different thing.
So, and then
how can a learned advocate of this court, when a proceeding has been disposed of, can accept that
Well, he's appearing as a counsel there, Mr. Tiwari. Mr. Agarwal. So first we tried to, your lordship's order was very clear.
But it is not correct.
Parallelly, I can't.
Impugned order.
May I just address your lordship? What had happened, your lordship recalls that the report of the psychologist or the doctor was placed. It was not shown before the subordinate court trial judge, and that was and that your lordship held that since he had himself opined that without showing it to a doctor, it would not be prudent on my part. And since the report is there, I don't want to look at it here. And your lordship rightly said that you better we took a conscious call and we filed an application. Because it was 6th of August that the content was being proceeded with. We said we'll file that application. The lordship very graciously allowed us. We went there, filed it on the 23rd itself. Went to a learned advocate appearing there before the trial court. He did not accept it. We called up this gentleman who's appearing there, Arpit Agarwal, who's appearing as a counsel there. And in pending all of the revisions, he is there. I've disclosed the call.
Here.
But if he doesn't,
Councils accept.
he accepted it. Well, that's what I'm saying. He very kindly accepted it because he was also here. My learned friend was here, so he must have instructed him that at least, we both understood that your lordship wanted the learned trial court to hear it. And on these rigmaroles, he correctly advised his probably advocate record here and counsel there to accept it. He accepts it. When we go and file it on the 23rd July and we've taken the specific pleading, there's a little more than what is meeting the eye now. Because my juniors are going and appearing. The learned trial judge said that you file it, you keep it on record, you go serve it and come back. So we said that he is not accepting. He said, I'm not taking this or filing right now. You just keep it here. It will not be deemed to have been filed. At 4:30, when nobody had appeared, and this he will also vouch because nobody actually appeared, he took it up of his own and passed this order of 23rd of July. Well, there is in substance compliance with the lordship's order.
Now, only one thing.
Now,
I accept that he has violated. I accept your submission. Now, have you got the recalling application?
Yes, Lord.
On
So-
20,
Lord, your lordship,
Mr. Banerjee, please.
Lord, kindly consider the order impugned.
Yes.
My learned friend, with due respect, each and everything is not. It is false, totally false. Kindly see the recording of the finding.
Mr.
Lord, on the
Ghosh,
first day, on 23rd, when the put-up petition was filed, they said that for the filing of the put-up petition, the time is going to over, that's why you have not served. Now they have come with an application for the second day when the put-up application was filed, it was directed to be served, and the learned second day. He is not saying about the first day. In terms of your lordship's order, kindly, my lord, see the finding of the impugned order, last paragraph. Last paragraph. What he is saying, Lord?
order dated.
আমাকে বকছে
Mr.
কেন?
Ghosh, at this age, don't
No,
get so much agitated.
আমাকে বকাবকি
Please
করছেন।
don't get agitated.
Lord, 25th July.
Considering your age, please don't get
He
agitated.
is not telling something which is beyond record.
Mr. Ghosh, after all, you are fighting for your client.
Yes. Lord,
And you are
scolding me.
Counsel, why are you
Lord,
getting agitated?
Lord, he is not telling the truth.
এ কি?
My lord, kindly see page 20.
Yes, order dated 25th of July.
2020.
Yes. Yes.
My lord, kindly.
Which paragraph?
Lord, last paragraph of this page, the learned advocate appearing for the opposite party at the time of hearing of the put-up petition has submitted before me that the time of filing put-up petition will be shortly over, and he has not been able to serve the copy of the same upon the learned advocate for the other side. And as today is the last day to file the petition, the learned advocate asked the learned court to allow him to file the said application, and being allowed, he filed the said application along with the copy of the order of the honorable court enclosed along with the same. After going through the copy of the order of the honorable court, it came to the notice of the learned court that the honorable court has been pleased to direct the opposite party to file an appropriate application for the court on or before 23rd July 2025, along with a put-up petition. After serving a copy of the same to the learned advocate for the petitioner in the Miss case, but as there was no information enclosed as to the service of copy of the said petition to the learned advocate for the petitioner in the Miss case, along with the petition filed by the opposite party, this learned court refused to accept the said petition filed by the opposite party, and as the petition was refused, the question of hearing of the said petition does not arise as prayed for by the opposite party. The direction of the honorable court was specific that appropriate application is to be filed on or before 23rd July along with put-up petition after serving a copy of the same to the learned advocate for the other side, and not that copy is to be served to the learned advocate to the other side after filing of the application. Now the said opposite party has come up with the present petition stating that the copy was served after filing of the said petition upon the learned advocate for the other side,
and the service made by the opposite party will not cure the defect which is already committed by the opposite party. Filing of the said petition by the learned advocate for the opposite party without serving a copy of the same upon the other side is a gross violation of the order of the Honorable High Court. The opposite party and the petition which is filed in gross violation of the order of the Honorable Court by the opposite party is devoid of merit and deserves no consideration. Lord, this is the order on the basis of second put-up petition, and he has held that earlier occasion they said that time is going to be passed. That's why I am filing it without serving copy. Now my learned friend is saying that we went there, court directed to intimate the learned advocate appearing before the High Court. All these things are story. These are not correct. But I am not very beginning till today. Let my learned friend show that any order has been complied.
May I just indicate this?
No order has been complied.
Because he's
not
forcing
kindly see the answers from father. He is deprived of visiting his child. Even if the psychologically retarded the child, father has right to see him.
Yes, no doubt. Father has the right. What is the next, Mr. Ghosh? What is the next date of visitation?
6th August.
6th August for contempt.
No, for contempt. What is the next date of? What is the arrangement of visitation?
Visitation, Lord, according to the direction, that 48 hours in a month, second and fourth Saturday.
Second and fourth Saturday at Pune.
At Bombay,
second and fourth Saturday at Pune.
In no, Lord, in Bombay, in a hotel.
Bombay.
Lord, initially, Lord, we wrote, they didn't agree, and ultimately, Lord, they proposed that on 28th and 29th of July.
No, there was no such proposal. Lord, if he going to, Lord, your lordship wants me to stay quiet, I've stayed quiet, but if he's going to go beyond my revision, this order was specifically not interfered with. If the learned court below wanted to have a psychologist report, he will not take up the recalling. Your lordship has seen, Lord, may I just argue my case now? Kindly have a look at page 125.
All right, take your seat, let him.
Kindly have a look at page 125.
Yes.
And Lord, before the criminal court also they considered that the custody
did not concede anything. Just it's a very short thing. Look, kindly have a look at page 125 once.
Yes.
On what ground this has been refused? The direction of the Honorable Court was specific. Second paragraph at 125 was specific that appropriate application is to be filed on or before 23rd July along with a put-up petition after serving a copy of the same to a learned advocate for the other side, and not that copy is to be served to the learned advocate for the other side after filing of the application. So what has happened? Well, undisputedly after serving, now I have served. My only thing that has weighed, and he thinks,
Banerjee, why have you not complied with it?
Look, I have complied with your lordship's direction. Only mistake that we've made
after.
No, before only.
No.
Kindly have a look at 73, page 76.
Yes.
And
after serving, you have to file.
Correct.
But it's the other way around which you have done.
What we've done is,
and
we've served. And
on
we
that
served it
also,
one week.
after violating the order, now you are saying.
Before 116, it was served on Arpit Agarwal, who took it before we filed it.
Show me
page 116.
Show me 116.
That day we served it.
Show me that you have served.
116.
Advocate.
On the advocate here.
Not the Dosha.
We went in the morning. He did not accept the filing. It was kept on record. Then it was given at 116 to Arpit Agarwal Milot on 23rd of July itself.
So this was served on 23rd of July.
23rd itself. At 12, around 12:30. Whatever be the.
All right, 2:30.
Let us accept. Yes, my only request, your lordship, is that the only request is your lordship's order is very, very clear. Apart from the procedural bit of it, it's very clear that since the report is there, the learned trial judge, when he holds that I want to have a look at it before I grant visitation, let him have a look at it since the report has come. Now the recalling is filed, the report is there, kindly directs the trial judge to have a look at that report. That's the only, today both of us are bickering here. The same argument we had advanced, and your lordship had rightly held that because in the 31st March order, he holds that it will not be prudent on the part of he calls the child, interacts with the child. and he holds that there is some amount of animosity. Your lordship recall that I had come to court and submitted that once we are in the court, we are agreeable probably to go. I have spoken to them also.
Is there application for recalling?
Yes, ma'am. Application for recalling is at page 64. And here also your lordship will find that we pleaded, my lord, that in a public place, let the father meet the child. The child is 12 years old, my lord, to send the child to a 5-star hotel or a resort for 2 days, 48 hours with the father, the child is resisting. I had made the submission in court that we are agreeable if the child meets the father in a public place for some time. Let the father meet. Let there some kind of a relationship develop. Then if the father wants to go and meet the child in a hotel, that the child will decide. Specific pleading is that. At 69, if your lordship looks at,
yes,
kindly have a look at page 10. I mean, so page 69, paragraph 10. The applicant state, may I, my lord?
Yes.
The applicant state it will be in the best interest of the minor child for the learned court to recall and modify its order after perusing the psychologist's report. In fact, as has been previously stated in the pleadings before this honorable court by the applicant's opposite party, due to circumstances that have occurred over the past few years, the minor child is adamant to not meet the petitioner despite the best efforts and persuasion of the opposite. However, it is rather prudent that direction be made by the learned court to meet the child in a public recreational place in Pune for approximately 2 to 3 hours, that is the minor's place of habitual residence for such intermittent period of time as this learned court may deem fit and proper. Such mechanism would allow the minor child to be gradually and smoothly become comfortable with the presence of the petitioner. Such mechanism would proliferate both comfort and convenience of the child as well as allow the petitioner to interact and visit the minor child. So specifically in terms of what was submitted, well, if your lordship wants, I can bring the child to court also, your lordship can interact. I have done that. It is going to be very difficult for the court or for me as a counsel or for the grandparents to insist that for 48 hours you go and stay. This is what I submitted in court also, and they said if this is the alternative that they are giving, then they are agreeable. Your lordship will pass this order today. Let the father meet the child. No, I am myself a father. I will not argue that a father will not meet the child. But at the same time, when the psychologist's report is there, without seeing, your lordship will never look at the report. On the last occasion also said, and your lordship rightly said that because it is there and the learned trial judge has not looked at the report, it will probably not be correct on your lordship's part to use up that jurisdiction and say that no, I am going to do it now. So we go place the report. He is adamant, my lord, on not looking at anything we file. In open court, he says that every order that we pass, and Mr. Naik was there. He says that in every order pass, you go to the higher court. I'm passing these 2 orders, you go to the higher court and test it. And a different impression, he can scream and shout, but a very different, now I'm saying it in open court, and I hope this is getting live streamed. Lord, we've taken this pleading also. Something is not right that is meeting the eye. Some impression is given when we're moving the matter. 4:30, nobody moved. I have a lot of love for my learned friend. He will vouch for what I'm saying is true or not. Nobody moved the matter. He gave a different impression at 4:30 in the morning. At 4:30, he took it up when nobody was there and he passed this order. My only thing is that the father must meet the child.
Which order was passed at 4:30?
The first impugned order.
That is at page
23rd.
117.
At Milord, page 117. 117. Well, let us not get into it. A 12-year-old child is involved. The father wants to meet the child. I want the father to meet the child. But I can't force something because I am an adult. Let the court, your lordship will pass that order. Let him meet in a recreational place for 4 to 5 months, for 2, 3, 4 hours. Let there be some kind of relationship that will develop. Your lordship will never look at the psychologist.
This weekend you are agreeable.
This weekend I am agreeable. Weekend is tomorrow. Child is in Pune. If the father goes, I'll just take him.
Mr. Ghosh, can you go this weekend to meet the child?
Next weekend, hello?
Don't do it
Yes,
next week
yes,
because
next weekend.
6th is the next date. I want to do it before that.
Next weekend, yes, I'm agreeable.
But 6th is the next date fixed.
But not
So
in
any,
Pune.
they want the whole purpose, the whole purpose.
Mr. Banerjee, let me hear, Mr.
Not in Pune, but at Mumbai.
No, this arrangement was that Mumbai or Pune?
No, child is in Pune. Milord, I can't bring the child from Pune to
What's the
Bombay.
difficulty?
Father
Not
can
RTR
try.
and there was a criminal
You are
case
subject to
asserted.
correction, your
Then
lordship
Mr. Banerjee, if there is a criminal case, not at Pune, at Mumbai.
No, there is no.
Mr. Banerjee, then at
cases have been settled. I'm given to understand by an order.
Mr. Banerjee, can you not bring in Mumbai?
No, my lord, from Pune to Bombay, the child will have to travel. This is an adult father. He has never shown any.
Mr. Banerjee is not an adult father. He will not
take a child.
He's going to Mumbai. So can you not bring?
May I just request this? Then your lordship will have a look at the psychologist report. I don't know what is there. I don't want to make this. Not a 12-year-old child is involved. Let him have a look.
He cannot be brought to Mumbai.
No, I don't know what is there in the report. What the psychologist has said.
That's not your case, Mr. Banerjee.
My case is that he should be meeting in Pune.
Because
the child
that
in a
cannot be
recreational place, in public place, in
that he
Pune.
cannot be brought to Mumbai. That's not your case.
The case is he has to be met in Pune. Let the father come to Pune. He's an adult.
Only for 1 weekend you cannot bring. That is why I'm asking you.
To Bombay?
Yes.
Then they'll say, I'll just take instructions. Bombay নিয়ে যেতে পারবে? আরে তোমরা মামলা করাও কেন যদি একজন find out. Let me find out next weekend because just give me 2 minutes. Find out and let me know. But this is a far better way to start the process, where they meet for 3 to 4 hours in recreational place.
Mr. Banerjee, yes.
And then there's some kind of relationship develops.
Will be considered thereafter. After all, the father could not meet his child for a long time. So that has to.
This prejudicial fact, I agree.
Yes.
But the father also made no effort to meet the child when the child was
allegation.
Bombay for 2 years.
Allegations and counter allegations will come.
Yes,
but the fact remains, the father could not or did not.
Which is why we have made this there in the recalling.
I can put it in a different way. There was no meeting between the father and the child.
Correct. As a matter of fact, they have not met each other.
That has to happen.
Correct. That has to happen. And they must meet at least for the child to develop some kind of a relationship.
That is why I want
the child wants to go something.
6th is the next date. So, and Mr. Ghosh said that on 28th and 29th it could not happen. Or it did not happen. Mr. Ghosh, you have taken instructions. Your client can go in this weekend.
I'll just ask him directly.
Yes.
Saturdays, Saturdays and 3-4 hours also be available. Sunday, your lordship will direct the father to come to Pune. 4-5 hours that the father wants to spend.
Mr. Banerjee, then it's difficult.
No, the father won't come to Pune. I will have to go to Bombay with the child. Why isn't he? Why doesn't he want to go to Pune? What is no? Don't do all that. Why can't he go to Pune? This is a matter of ego.
If you both of you are on ego,
so I'm saying, I am.
Then it's difficult. Mr. Banerjee, where have you stated that you cannot bring the child?
I have why?
Show me.
I have not said that. I've said that the child can meet in Pune.
No, that's a different thing altogether.
I don't want to make this and this.
How much time it takes from Pune to Bombay?
At the same time, 3 hours it will take. The same time the father can spend and come to
Banerjee. It's not that the father cannot go to Pune for 3 hours time. It's not that.
There are no criminal cases pending.
He says that. Who will take the responsibility? Who will take the responsibility?
My instructions are there. We'll take the child to Bombay. My instructions have come. Your lordship will direct Sunday after next Sunday.
This Sunday.
Not this Sunday.
Mr. Banerjee, this Sunday. It has to happen this Sunday. This Sunday you can bring. He can go from here. This Sunday you have to bring. Something has to happen prior to 6th. Show your bona fide.
No, prior to the 6th.
Yes.
Next Sunday you'll be able to go.
For weekdays as well.
Oh, 6th is a Wednesday. ঠিক আছে Sunday নিয়ে যাও তাহলে third.
Sunday what would be the convenient time?
Sunday কখন বলো?
And in Mumbai, what will be the convenient place?
There has to be
any public place that the father can.
Mr. Banerjee, I can adjourn it. I'm taking it up 1 p.m.
I take these instructions.
So,
yes.
Specify the place, specify the time. On Sunday,
any restaurant or a
Mr. Banerjee, please.
I will yes.
Communicate to him because they are also taking instructions. Then he will say this is that far. He will say
3-4 hours the child will meet on Sunday. A little later, ideally in the second half because I have to take the child for 3 hours.
Yes. That Mr. Ghosh.
Ideally on the second half, and the child can
communicate to them.
Yes.
What
we can come back.
What would be the time?
No.
child also has to return to Pune on that day. So don't make it.
I don't have to come back. I don't have to come back. My instructions have come. After 1:30, any place in Bandra, if they want to meet in any restaurant, we'll bring the child.
Please specify that what is the place.
They can choose the restaurant. I'll take the child.
Make it a restaurant, mall, or something. I think will be better if the child can also have some restaurant.
Restaurant into ठीक ना.
Mall. What is the age of the child?
13, 12.
In play zone or
where he can also roam around, have
Yes,
some
yes.
kind of.
So, restaurant will be a
Restaurant বসে কি করবে? 4 ঘন্টা ধরে খেতে পারবেন।
and any expenses, Mr. Ghosh, if the child for bringing the child that you have to.
There is a global
from Pune to Mumbai. If any cost, if Mr. Banerjee wants, that you have to bear.
I don't think.
All right.
Cost of no for us to travel.
Now come at 1 p.m. Please.
We can decide on the place and then
place, time, everything. Put it in a piece of paper.
It's not about cost. It is only about ego. This is what I can. No. There is no. It's also about a child.
Since Mr. Banerjee is there will be no egos now.
Also about a child.
Mr. Banerjee and Mr. Ghosh both are here, so I know that there will be no egos.
In fact, this suggestion on
both of you have to keep aside your egos when it's a matter of a
the
child.
father must meet the child. This Lord, I was adamant on from the time he came and spoke to me. It can't be that the father will not meet a child.
That is why.
But that little safeguards that we'll also have to take, that we've taken, we'll come back at 1 o'clock.
That might be one of the reasons why the learned judge
is also possible.
That is why.
What is hurting my conscience?
Start to 6. Anything start to 6. Please do it. I think, yes, call the next matter.
Milord, I oppose this application.
Will modify that order, Milord, which are facing contempt.
What?
After this arrangement happened.
Banerjee, come there after I.
17 for the petitioner, Milord. I oppose this application. It's against an order passed by the DRT.
Passed by the DRT.
The DRT is available.
Let me indicate. It's an order passed by the DRT. At the time when the DRT was filed, the DRT was not holding off.
Now DRT is there.
Come back from today. So I know your lordship's view. I have to go back. Kindly permit me to withdraw my certified copy.
Yes, Mr. Shah, you cannot have.
For once, he cannot object.
Milord, I will try to portray, Milord, a more malleable, Milord, persona, Milord, that Mr. Bordhan has of me, Milord.
No.
He thinks I fight with him for everything, which is not true.
Certainly not, sir.
When this matter is taken up for hearing, Mr. Bordhan, learned advocate for the petitioner, submits that this application was filed at a point of time when the debt recovery appellate tribunal, Calcutta, was not functional. First up,
No, Milord, he had just gone, Milord, for a camp to Vizag for 5 days.
was not available. Was not available. Full stop. Paragraph. He therefore he submits that since the debts recovery appellate tribunal is now available, he pays for leave to withdraw this civil revision application with liberty to approach the appropriate forum in accordance with law. Full stop. Mr. Shah, learned senior advocate, appearing for the. আচ্ছা এটা উপরে দিয়ে দেবেন একদম মিস্টার শাহর অবজেকশনটা একদম উপরে দিয়ে দিন Mr. Shah, learned senior advocate appearing for the opposite party, raises a preliminary objection as to the entertainability of this application under Article 227 of the Constitution of India, challenging an order passed by the Debts Recovery Tribunal, Kolkata 1, in view of existence of an efficacious alternative remedy under the relevant statute. ঠিক আছে, এটা একদম উপরে দেবেন, তারপরে মিস্টার বর্ধনের সাবমিশনটা করে দিন, করে দিয়ে বলুন in the light of the submissions made by Mr. Bordhan, learned advocate for the petitioner, CO number such and such, stands dismissed as withdrawn with
disposed of.
has to be dismissed as withdrawn.
Then with liberty to move?
Yes, yes. Dismissed as withdrawn with liberty to approach the appropriate forum in accordance with law. Paragraph: the learned advocate on record of the petitioner shall be permitted to take back the certified copy of the order impugned by replacing the same with a photostat copy thereof.
And my lord has not entered into the merits of the matter.
Withdrawn.
Kindly. My lord, kindly. What? Kindly includes the the court has not entered into the merits of the matter. Kindly does it in this matter. I say.
Why?
I beseech my lord to kindly.
It's a withdrawal with liberty.
Yes, my lord, kindly does it. My lord, the records which show something else. My lord, these points are.
What?
All right. It is, however, made.
I don't stand in the way, but my lord, this is perhaps not a fair submission to make. I don't stand in the way. Nothing turns on that. But my lord, I don't know, my lord, imputations are being made against whom, but perhaps not so fairly.
No, Mr. Shah, he has not said anything against you.
No, not against me. Not against me, my lord. If he says anything against me, I will deal with him outside court. If he says anything against me, my lord, I will deal with him outside court. But my lord,
please take care of Mr. Bondon outside court.
Very good.
You know, it is, however, made clear that this court has not entered into the merits of the claims and counterclaims of the respective parties as claims and counterclaims of the respective parties.
Very good.
I'm so grateful.
Deeply blessed.
For one for judgment.
Well, I'm for the petition, my lord.
Yes.
12 p.m. fixed matter. Item number 78.
Discuss. 5391.
1850.
না None appears for the petitioner at the time of call. No accommodation has been sought for.
Item number 121.
Yes, Mr. You are appearing.
59-1. No. 1 Sanjay.
No, 1124. No, sorry. 1079. CO. Who is appearing?
This debate will be so thoughtful.
Yes.
My lord, I am for the petitioner. In this matter, my lord, the short point involved is
Hot point.
I am the plaintiff, landlord. I file a suit for eviction in which the original defendant, landlord, tenant has already submitted his written statement as well as evidence. He was being cross-examined. At that stage, he expired. And after his death, his only son gets substituted, comes in and files a counterclaim on a completely different point, and also filed additional written statement claiming his independent title, not claiming his independent title, but saying that they have a right to property on adverse possession. Whereas his predecessor father has admitted that in the written statement that they are tenant. Learned trial court is
which order you are challenging?
My lord, the order, there are 3 orders which are challenged. In fact, there is a learned trial court admits that.
No, you are challenging the order dated 13th of December 2024.
I am challenging the orders dated 5th April 24, 21st June 24, and 1st February 25.
1st February?
Yes. Lordship, kindly
What is 1st February?
Kindly comes to 1st February order.
No, you are not challenging the order dated 13th of December 2024.
I am not challenging that.
That is regarding adoption of the written statement by the substituted defendant.
Let that written statement filed by the original defendant be adopted. I have no issues on that.
All right.
But kindly turns the page, the next order. Kindly says that my application for rejection of the additional written statement and counterclaim filed by the substituted defendant has been rejected. On the ground that when it was filed originally, I gave consent, but I never gave consent.
What? Adoption of the written statement.
Adoption of the acceptance of the additional written statement and counterclaim.
Where it has been stated that it is on consent.
Kindly say, heard considered. I have gone through the case record and it appears that VD order dated 5th April 24 and 21st June 24. The additional written statement has been accepted and therefore the instant application of the plaintiff on 16th May 24 has no legs to stand.
So additional written statement has been accepted.
That is my humble submission.
No, show me the order dated 21st of June 2024.
Lordship, before that, I will submit a list of dates which will help Lordship to understand which page numbers. Lordship kindly says how the matters got confused.
Who is responsible for that? For that confusion, Mr. Mukherjee?
Better I skip that question. Lordship kindly comes
of June. 21st of
Lordship kindly comes to page 63. I have annexed all the orders. Lordship kindly comes to order page 1.
Mukherjee, please kindly come to order dated 21st of June. You have not raised any objection with regard to the acceptance of the additional written statement.
I am still not raising objection additional written statement.
Yes,
but in the subsequently there are 2 additional written statements. That's what I want to show.
Now the evidence is closed.
No.
Cross-examination
was going on of DW.
Cross-examination of DW.
DW was going on. Who commission? At that time, DW, the original tenant, expired. My cross-examination
counterclaim set up at a stage of cross-examination of DW.
At the stage of cross-examination of DW.
That was allowed.
That has been accepted.
That is in the additional written statement.
Yes. Which in my humble submission, Lordship knows very well.
Where is the decision which says that counterclaim at the evidence stage cannot be accepted?
It is counterclaim cannot be accepted after framing of issues.
Where is that decision?
I have it, 2019 decision.
Not 2019, it's 2020.
2020 decision where the Honorable Supreme Court has said that it can be accepted only up to framing of issues.
There is another rider, another exception stopped out in the later portion of the
paragraph 23 possibly. But my
there is substance in the argument of Mr. Mukherjee, learned
since the substituted defendant cannot claim an independent title on the property,
I've admitted in on what
one
one
point,
ground.
I will urge that also.
You may-
Lordship will know Sir Porimal's judgment.
Item number 18.
Even this judgment don't rely upon that. Do you have the Supreme Court judgment on that?
Yes, 1972, or Razia Begum.
After that went up to Supreme Court.
That time,
So
that time.
bring the Supreme Court judgment also on Purimal.
Item 189.
I'm afraid.
I appear for the petition in this matter, my lord. This is a non-adversarial proceeding, my lord. My lord, the return of will, the original is still lying with the district judge at Barasat, my lord. The difficulty is the executor now cannot proceed with the subsequent application before the appropriate court. The matter was returned, an application akin to Order 7 Rule 10 was filed, which was allowed. Other on the last occasion,
No, praying for return of that will. What happened after that?
well, that's still there with the district judge.
No. This 151 application was filed. What is the fate of that 151 application?
151 application, the order passed was nothing could be done.
Where
since
is
the-
that?
Yes, I'll indicate. If your lordship kindly takes up the application.
No. Where is the order passed on that application?
My lord, order number 37, which is appended to my revisional application, my lord, 12th June 2023.
No, after that 38 is there. You have filed
Yes,
an
38,
application.
my lord, petitioner files a put-up petition along with an
What happened to this petition?
Nothing happened. Because the case records have been transferred to the district judge, so naturally it's in the safe custody, nothing has been dealt with. The district delegate has disposed of this application, my lord. In fact, it has been kept in suspended animation, my lord. Nothing has happened since the matter now, the original will has been sent to the district judge. That is the difficulty.
And in which court you have to file?
My lord, district delegate was the court.
Yes.
Now, in terms of Rule 305, since no will was granted, my lord, it ought to have been returned. What the district delegate has done is, in case of probate being granted, it is transmitted to the district judge in terms of Rule 305 of the Civil Rules and Orders. Now, my lord, accordingly, it has not been returned as if it's a probate had been granted and the matter has been transmitted, the original will has been transmitted to the district judge. So this is the difficulty, my lord.
201, my lord, Mr. Anishdo Chatterjee is appearing, my lord, through online. I'm for the petitioner, my lord.
Item number?
259, my lord.
201, yes.
My lord, it's a, my lord. Appearing, my lord.
Yes. He is busy. এটা কি দিলেন পার্থপ্রতিম রয় তো এটা কি
Milord, may I Milord, I beg to appear, Milord, behalf of the petitioner.
পার্থপ্রতিম রায়
পার্থপ্রতিম রায় কোথায়?
ভিডিও দেখতে পাচ্ছি না তো কাউকে দেখতে পাচ্ছি না
there is no one to assist you, Mr. Rai. No,
Milord,
Mr.
I am there to assist him, Milord.
The one
Chatterjee is appearing.
in this matter.
Yes, I have briefed him.
Oh.
So this is that matter where your lordship,
Mr. Rai, you are for the petitioner. You are standing for the opposite party.
No, I'm for the petitioner. I'm for the petitioner.
No, Mr. Parthapratim Rai. What is your CO number? 3391 of 2024.
Yes, my lord.
Mr. Rai appears for the petitioner. It has been recorded.
I am for the opposite.
Junior is Raj.
Milord, kindly send him to Bar Council, Milord. Milord, kindly send him to Bar Council, Milord. He is appearing for both parties.
Opposite party is going to. Oh, তাহলে wrong recording হয়ে গেছে। আসুন। You are appearing.
No, Milord, kindly send it to the Bar.
It has been submitted that the appearance of the learned advocates have been wrongly recorded in the petition dated 14th of July 2025. First up, Mr. It is recorded that Mr. Parthapratim Roy and Mr. Rajdeep Bhattacharjee appeared for the opposite parties, and Mr. Mohendra Prasad Gupta, Mr. Ayan Mitra and Ms. Moumita Dhar represented the petitioner on that date. Yes, Mr. Chatterjee.
Last occasion, probably Mr. Chatterjee there. Last occasion, my lord was pleased to ask whether any compromise or mediation can be effected between the parties or not.
Yes, what is their instruction? Yes, Mr. Chatterjee, yes. What is their instruction?
I have
the compromise. What is the compromise? Why? What is
the husband and wife, my lord? This is a suit for dissolution of marriage. My lord, may Mr. Chatterjee start. Now, an application has been filed for amendment. That was rejected. Against that, they came up for application. Now, during that course of hearing, your lordship, it is a desire of the court and also the other side. What is
your instruction? If that is.
No, I have not received any instruction, my lord, then I have to talk to my client also, my lord. I have to take some instruction, my lord.
Yes, then I am sending to mediation.
Let it be taken up on Monday, my lord. In between them, my lord, I will take my instruction, my lord. Then, my lord, Monday, my lord. Kindly fix it.
Monday or which day, I do not know. The learned advocate for the respective parties seek an accommodation to take instructions from their respective clients. First up, the hearing of the civil division application stands adjourned for this day. Yes, next.
Grateful.
Item number 2110. 210.
Appearing for the opposite party and led by.
Yes.
I beg to appear on behalf of the petitioner.
Yes.
Dr. Mr. Chatterjee is on, but he's appearing virtually.
Lordship,
yes,
there is a last direction. Not the arising out of eviction suit. Defendant tenant.
Yes.
Now, my lord, on 20th.
Milord, on the last occasion, there was a direction, Milord, to file an affidavit.
Yes, supplementary affidavit.
No affidavit forthcoming.
Supplementary affidavit, my lord, I did not file, my lord. It is not required. I will submit before. Why, my lord?
Why?
I will submit before it. Now, 24th of March 2023, my lord, I, as a tenant, entered appearance in the suit.
Bonik, you don't have these copies of these challans. You don't have the copies of these challans.
No. Kindly, these are not required. Your lordship, kindly hear me first.
Copies of those challans.
Not required, my lord. Your lordship, kindly hear me first.
So, please first comply with the court's order. Whether it's required or not, I will consider thereafter.
Your lordship, kindly sees 24th of March.
Bonik, I will consider whether it is required or not. Please first comply with the order.
My respective submission is, my lord.
My lord will kindly, my lord,
Mr.
will
Doctor,
kindly consider one thing.
Mr. Doctor. So you don't need to. My lord is saying. Please
Yes.
relax.
Then, my lord, if I don't file any challan or even did not deposit the rent for those period, my lord, should I be evicted on the ground on the provision of 7.3? Whether 7.3 is applicable on the ground?
All right.
Your lordship, kindly sees 24th of March 2023. I entered appearance as a tenant and filed my application under 7.1 and 7.2. Now, in 7.1 application, I made two prayers. Two application was fine, that should not be, but your prayer was two. One is, I may be permitted to deposit the area rent 19,000 and odd, and second prayer was to allow me to deposit the current monthly rent. Your lordship, kindly have a look to the order. 7.1 was disposed of on that very date when the application was filed.
Page.
The certified copy has been annexed.
So certified copy.
Yes. Order number 9 dated 24th of March 2023. Sorry.
Yes.
7.1.
Yes.
Your lordship has got it. Record is put up today by petition filed by the defendant. The defendant appeared by Vokaratnama along with petitions under section 7.1, 7.2, such and such act. Copy served. Heard, learned advocate of the defendant with regard to petition under section 7.1 of the West Bengal Princess Tenancy Act filed by the defendant is hereby considered and allowed, but at the risk of the defendant. Defendant is hereby permitted to deposit the current rent month by month as paid for in the court by challan. This is the precise order made by the learned court that directed me to file or deposit the rent month by month, and that has been done. 7.2 application never been heard. What happened? Thereafter, your lordship, kindly have a look to the order dated 14th of May 2024.
14th of May
2024, order number 18.
Yes.
Prior to that, I filed the written statement in belated state. That is why 2,000 cost was imposed. I paid the cost. Now, 14th of May 2024, order number 18. Today is fixed for hearing under section 7.2 and 7.3 of West Bengal Princess Tenancy Act. Both parties file hajira. The case is taken up for hearing, heard both sides at length. Till date, no rent control challans have been submitted till date. No receipts has been submitted in view of order dated 18th of March 2024. Your lordship, kindly sees the 18th of March order. There is no order as such on 18th of March 2024. Considering the situation, application, the direction was made to show me the challans. The challans has not been shown to the learned court. That is what the 7.3 application was allowed.
Payment of cost.
On that very date, my client was sick. He was not able to come to court. That is why I filed the application. Rather, I sought to file the application. Your lordship, kindly have a look to the annexure. Annexure B, page 47. Now that has not been considered. 7.2 allowed. Now thereafter, on 1st of August 2024, just 1 year before this date, your lordship kindly sees order number 19.
No, page 47. What is page 47?
47. This is my application. Praying for time.
This is for paying for cost.
Cost. There.
So cost was with regard to written state.
Yes, that on that. So paragraph number 2, I stated that since my client was not
maybe,
able to,
but that is with regard to cost. Nothing with regard to 7.2.
No. Your lordship kindly sees that 1st of August 2024. Thereafter. The application was made for recalling that order, that 7.3 application, whereby my defense has been struck off. 1st of August 2024. Today is fixed for framing of issues and payment of cost of rupees 2,000
both sides are present, cost 2000 has been paid and accepted. On 14th of May 2024, both the sides were present by filing hajiras, as hajira applications can be found in the record. Both sides verbally made submission on that date. Date was fixed on 14th of May 2024 for hearing pending application under section 7.2 and 7.3 of West Bengal Premises Tenancy Act. The defendant side made certain submission on that date, but did not produce any challenge in order to prove that they are still paying the rent in the office of rent controller. Application under section 7.2 of the West Bengal Premises Act was filed by the defendant on 24th of March 2023, and since then they could not file any or all the rent receipt challenge. As such, his defense was struck off.
When you
so 7.2 application has never been heard. If I am defaulter in payment of rent, where the application, my respectful question, Milord, I putting my question myself, where should I go? What application should I file if I have any area rent? In which proceeding that court is supposed to deal with the issue? 7.2 application, that has never been heard. I specifically stated in my 7.1.
That is the 7.2 application.
Your Lordship kindly sees page 11. Beg your Lordship pardon. Page 14.
14.
1-4. Prayed before your honor may be pleased to determine the dispute whether the defendant is a defaulter in the payment of monthly rent for any month by month, and upon determination of such dispute, if the learned court be pleased to find that the defendant is defaulter in the payment of monthly rent for any month or months, such amount of area rent may be directed to be liquidated by the defendant in accordance with law under section 7.2. That scope has never been given to the defendant, tenant.
Which scope?
7.2. 7.1 application hard.
When did you file this 7.2 application?
Immediately. The date is okay.
Have you deposited the admitted amount?
That is why this is no understood fast. 7.1 application.
I'm asking you.
Two prayers there. I've started with this submission. One prayer is that I have some area amount.
Mr. Bonik, there are two things. Did you dispute the rate of rent?
No.
Did you dispute the period of default?
No.
Then where is the question of 7.2 adjudication?
Your Lordship kindly sees 7.1.
Mr. Bonik, 7.2 comes if there is a dispute with regard to the rate of rent, period of default. Since you have not disputed, no question arises for deciding 7.2.
I have not specifically in my application have stated in 7.2 application that if there is any default,
dispute, sir. There are two things. If there is no dispute, after appearing, you have to continue to pay under section 7.1.
Yes.
You have been allowed to deposit. So where is the question? You have not raised any dispute. Only the dispute has to be adjudicated.
Your Lordship kindly sees the 7.1 order. I am guided by the order, nothing else.
Yes, yes.
If the order says that you are required to pay the amount month by month, that I have done. What wrong I have committed?
All right.
I have not paid the amount.
Show me the order under 7.2 is that. So 7.2 need not be decided because there is no dispute. Mr. Bonik, you have complied with 7.1.
Yes.
There is no default according to you. 7.2, no dispute. It does not require any adjudication.
So far as the 7.1 is concerned, I have specifically stated that there is a area rent, which I have not paid. 19,000 and odd.
Then that is the admitted amount.
That is admitted amount, but that is not made at the time of adjudication.
Bonik, did you pay that? Are you along with 7.1 or 7.2?
No, 7.1 not paid.
Then
your Lordship kindly sees I am guided by the order.
What
Your
order?
Lordship kindly sees the order, 24th of March.
Yes.
Your Lordship kindly sees.
Yes.
Once again, Your Lordship kindly sees.
Yes.
Defendant is hereby permitted to deposit the current rent month by month as paid for in the court by challan.
Yes.
I did so.
Yes.
I
but
started
with regard to
depositing.
the, Mr. Bonik, with regard to the areas, what have you done?
Look, if not, that has not been area permitted. Since
My
there,
lord, I may just indicate
Yeah.
one thing.
Direction
Under
is
7.1,
here, Mr. Bonik. It does not require any direction.
True, my lord, but then I followed the direction.
What you followed the direction?
The direction which has been
It
made
did not
by
say that you did not have to pay the areas.
Your Lordship, kindly see the direction is there to pay the month by month current rate. That I have.
Mr. Bonik, the direction is at your own risk you do it. It does not say that you deposit this, you deposit that. You have
No, no,
filed an
that's
application, it has
my-
left
my-
it to you
I respect
at your own risk, do whatever you want.
respect to
And
subsidiaries.
7.1 does not require any order to be passed also.
My
Application is necessary.
Not even an application is
Also
necessary.
required.
Not even an application.
Direction is specific.
Where is the order passed under section 7.3?
Your Lordship, kindly see page order number 19, dated 1st of August 24.
17.
Oh, sir, order
19.
number 18, 18.
18, 14th of May 2024. Ground is no challan has been submitted. Rain control challan. Rain control challan has not been submitted. This is the ground.
That is why I gave you leave to file supplementary affidavit. And you are saying that is not necessary.
Milord,
That is why I have given you leave to file
some of
supplementary
the
affidavit.
challans are missing. Milord. I should
You have not
send it
shown
to your Lordship.
anything.
Some of
Now you are saying some challans. You could have.
Milord, I followed the order. I'm stick to my submission. This this is my submission, respect to submission before your Lordship, that by the order dated 24th of March, the court has directed me to pay the amount month by month by in a court. I followed that. Thereafter, 7.2 has never been adjudicated.
Mr. Bonik, 7.2, there is no dispute. What will be decided? You yourself has admitted there is no dispute.
Have a look to the act itself.
Even if there is no dispute, it will be adjudicated. What will be adjudicated?
May I?
Yes, yes, place 7.2.
If in any suit referred.
Yes. Yes.
Referred to in subsection 1, there is any dispute as to the amount of the rent payable by the tenant.
Yes.
The tenant shall within the time specified in the subsection.
If there is any dispute, there is no dispute. Next cannot follow.
As per my assertion, there was no dispute because I stated this is the area amount.
The Bonik, it's the tenant's obligation. If he raises a dispute, plaintiff has filed a suit stating certain grounds, alleging you to a defaulter from certain month at certain rate. According to you, you are not disputing neither the rate nor the period of default. So there is no dispute. What will be adjudicated? Only a dispute has to be adjudicated, Mr. Bonik.
And your Lordship kindly sees the amount which has been stated in the plaint is 1,50,000. That is with damage and all the things. I can say that the dispute has been raised by them or not. Your Lordship kindly sees the 7.3. If the 7.1 and 7.2 is not followed, then 7.3 is applicable. Automatic. Now 7.1, now I'm asking the question myself, that whether 7.1 has not been, order has not been followed or not.
Anything more?
I have followed the order which has been passed by the learned court directing me to deposit the rent.
Facial expression shows that what is there in your.
I'm
facial expression.
Yes,
anything
Sir,
more?
what has followed from from my lord, beloved? Lastly,
I followed the order and I deposited the amount as directed by the court.
Yes. Yes, Mr. Chatterjee.
there are two very important things, beloved. he himself has admitted that he has not paid the below the admitted dues. If he hasn't paid the
You are
admitted
not
dues,
visible, Mr. Chatterjee.
but the video, my lord, it has unstable connection.
No, from your end. Then your presence cannot be recorded, Mr. Chatterjee.
Lord, I'll just try. Lord, video to on হচ্ছে না কেন? But there's some problem, my lord. Before whenever, my lord, it is connected, my lord, your lordship will see. My lord, he has admitted that he has not paid the admitted areas.
What is the admitted areas?
He has himself said in 7.1 and 7.2. The 7.1 and 7.2 applications, my lord, are verbatim same. Have a look at the 7.2 application, my lord, your lordship will find there.
Yes.
Are verbatim same, page 11 and page 14.
Yes.
My lord, your lordship will find it's verbatim same. So he has admitted that he has not paid below the areas, admitted areas. So the rigors of 7.1 fault comes in. Below 7.2 cannot be adjudicated if the admitted areas are not paid along with the application.
Cannot do.
And he has admitted in his
Mr.
application
Chatterjee, you
that
are
he has
also
not
not
paid.
audible, Mr. We cannot hear you.
Below, whatever, if lordship hears it, below, it's fine, below.
As well as my learned friend.
Learned junior also cannot hear you.
Below, lordship can hear me, my lord.
No, no, if the other side also has to hear you, Mr. Chatterjee.
Below, whatever is there
Will hear
on
you
his
because they have to
petition,
respond to your
lordship sees
submission.
it, doesn't have to hear it. Below, your lordship
Present physically also cannot hear you.
Milord, may I most humbly, Milord, pray before your lordship, kindly seize the application once.
Yes.
Kindly turns to Milord, page 11. I'm sure Mr. Bonik is hearing me.
Not
Page
audible.
11.
Not audible. Not at all audible.
Not at all audible, he says.
Very well.
Not just audible.
It doesn't matter. Seize his petition. Kindly seize his petition.
Yes.
Kindly turns to Milord, page 11. Kindly have a look at paragraph 3.
Yes. But Mr. Chatterjee said that the court has passed this order. Mr. Bonik
No, Milord, there is no question of an order being passed under 7.1. My first point before your lordship is this. The duty of the tenant to put in the admitted
your voice is breaking and you are not very audible.
Lordship, may I be permitted?
Mr. May I request my learned friend to say more because I've told her what is to be said.
Yes,
certainly.
Yes.
Lordship, come to page number 11 and 12.
Yes.
7.1 applications filed. Two.
Yes.
How come 2 applications is not required for depositing admitted area or current rent? Still at 2 applications. One at page number 11, and, continuing till page number 13, and other at page number
17
continuing till page number 19. Kindly see the first application. Kindly come to the prayer. Paragraph number 3, what Mr. Chatterjee was just now pointing. Paragraph number 3. Lastly, the plaintiff number 2 accepted rent on 14th August 21. Our period of default starts from August 21. For a period of 3 months, being May 21 to July 21. So they have paid till July 21. Admitted case. So.
And what is your plaint case?
August 21.
August 21 defaulter.
Yes. Now, thereafter, the plaintiffs did not accept any rent. It is an obligation. After lapse of a year, they are admitting this defendant requests the plaintiff number 2 several times to accept the rent as per normal routine. However, the plaintiff number, they are waiting for 1 year. It is at their risk. Lordship, come to
Lord, am I audible now?
Yes, Mr. Chatterjee, you are now very much audible.
Now, Kylie turns to Lord, page 11 once.
But not visible, Mr. Chatterjee.
Lord, visible also, Lord, I'm trying.
Yes.
Am I visible, my lord?
Yes, yes. Now I know the reason why you are not visible.
Lord, I have changed the device in the meantime.
So there is another thing. Now I can guess why you are not visible. Yes.
Well, kindly forgives me for that. It's a personal problem, Lord. Kindly have a look at page 11 once.
Yes.
Kindly seize, Lord, paragraph 3.
Yes.
And this is his application. Milord will find that the plaintiff number 2 used to accept rent in respect of the suit property, and she was in a practice to accept rent for the consolidated periods of 6 months to 1 year as per her whims. Lastly, the plaintiff number 2 accepted rent on 14th of August 21 and for a period of 3 months, being 21 to 20 or July 2021. Thereafter, the plaintiff did not accept any rent. This is his own, Milord, prayer. Then, if your lordship sees,
Yes.
the 7-2 application, my lord,
Yes.
kindly search to
August 21 থেকে till now.
আমি পড়াচ্ছি 7-2 তে পড়াচ্ছি।
Yes.
Lord, your lordship will find there is a problem.
More or less same allegation.
Same allegation, same thing. And it is an admitted position there, my lord, that he has not paid the admitted areas. Forgets about an adjudication. 7-2 first part is, my lord, that if he wants a 7-2 adjudication, he has to put in the admitted areas. That's law. If he doesn't do it, my lord, he has to come within the rigors of 7-3. Remembers, my lord, Nasiruddin's case, my lord, the instant application, the instant act, my lord, is not only for the benefit of the tenant, but also for the benefit of the landlord. So if he doesn't accept, if he doesn't go, my lord, by the act, he has to face the rigors of 7-3. And that's exactly what has been done.
Chatterjee, now the issue is pending before the Honorable Supreme Court.
Well, not with respect to this. It is with respect to extension of time. Here, he has not even paid the admitted areas. Issue is not with respect to, my lord, this at all. It is with respect to extension of time. Nothing more than that. 7-1, there is no question of extension of time. 7-2, yes.
No, but Mr. Chatterjee, the issue before the Honorable Supreme Court is with regard to 7-1, not 7.
Even with this, my lord, here, in that case, whether he needs an extension or not, he has not prayed for an extension. He is saying that I will not deposit because the court has said that I will not have to deposit. He has not paid for any extension.
What do you say to this order? Mr. Bonik says that the court has only directed him.
My lord, the court has no power under the law to direct anybody under 7-1. That is something that he has accepted and he wants to go by it. My lord, it's his problem. But law doesn't say, my lord, a court will pass any orders under 7-1. It's an act of the tenant. It is a voluntary act of the tenant, and it is something that he needs to do under the law to, my lord, have protection under 7-4. My lord, your lordship remembers 7-1 doesn't contemplate of an application. 7-1 doesn't contemplate of an order. 7-1 is an action of the tenant.
Mr. Chatterjee, if 7-1 does not contemplate an application, but that issue with regard to extension of time.
Lord, he has not paid for extension. He has not paid for extension.
No,
I'm
not on, but that issue is pending before the Honorable Supreme
But
Court.
that issue might be, this doesn't affect us in this matter. In other matters, it might affect us, but in this matter, it doesn't affect us. Because Mr. Bonik is very candid in telling your lordship, my lord, that he has not paid. And neither has he paid for, my lord, any extension of time.
Yes, Mr. Bonik, anything in reply?
But so far as the no order is required, when the application was filed 7-1, the automatic it cannot be, my lord, deposited in.
Who says?
Yeah,
My lord,
Baba.
Who says?
7-1 application, my lord, in.
Who says, Mr. Bonik? Where do you get that? Show me the statute.
Without that, the authority, the department will not accept the rent.
Yes, Mr. Bonik. Where is this? What does the statute say? Show me from the statute. 7-2 requires an adjudication.
Yes.
You may say yes, unless an order, you cannot be permitted to deposit. Show me under section 7-1.
Specific order on 24th of March. If I understand,
Mr.
there is
Bonik,
no order.
that's a different thing altogether.
There is
But who says that without an order, the department will not accept?
If that be so, my lord, that a part. If I, my lord, accept that proposition, my lord, that without any order, the rent can be deposited on that day, at the very date when the defendant appeared, or within 30 days. Now, so far as in my case, my lord, the order, specific order is there. If, my lord, I followed the order, what, my lord?
That you have submitted, anything with in
This is
respect. This application under Article 227 of the Constitution of
Great.
India, the instance of the defendant, and is directed against the orders dated May 14, 2024 and August 1, 2024, both passed by the learned Judge 12th Bench Civil Court at Calcutta. Now it's before the Chief Judge.
This was transferred to the learned Chief Judge.
But these are orders under challenges of the 12th Bench.
Yes.
Civil Court at Calcutta. In ejectment suit number 18 of 2022. Ejectment suit number 18 of 2022 is after transfer or before transfer?
The number retains.
Number retains. 18 of 2022. Post up paragraph. By the order dated 14th of May 2024, the application under section 7 within bracket 3 of the West Bengal Premises Tenancy Act was allowed. Thereafter, we filed 151. This was disposed on 1st of August. The petitioner filed an application under section 151 of the Code of Civil Procedure, praying for recall of the order dated 14th of May 2024, which was rejected by the order dated 1st of August 2024. Paragraph. The opposite party herein filed a suit for eviction on the grounds enumerated under Section 6 of the West Bengal Premises Tenancy Act 1997. The petitioner herein filed an application under Section 7 within bracket 1 of the West Bengal Premises Tenancy Act 1997 and an application under Section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997. First up. The learned trial judge, by an order dated 24th of March 2023, allowed the application under Section 7 within bracket 1 of the 1997 Act, permitting the petitioner to deposit the current rent month by month as paid for in the court challan. First up. Paragraph. Mr. Bonik, learned advocate appearing for the petitioner, submits that the petitioner prayed for an order allowing him to deposit the area rent from the month of August 2021 till the date of filing of such application by filing the application under Section 7 within bracket 1 of the 1997 Act, and the learned trial judge permitted the petitioner to deposit only the current rent month by month. First up, he submits that the petitioner complied with such order after the passing of the order dated March 24, 2023. First up, Mr. Bonik submits that without an adjudication being made on an application, without an adjudication of the dispute, he submits that without an adjudication of the dispute raised in Section 7 within bracket 2 of the 1997 Act, the learned trial judge ought not to have struck out the defense of the petitioner against delivery of possession by invoking the provisions of section 7 within bracket 3 of the 1997 Act. First paragraph. Mr. Chatterjee, learned senior advocate appearing for the petitioner, for the opposite party, draws the attention of the court to the statements made in the application under section 7 within bracket 1 of the 1997 Act, as well as the application under section 7 within bracket 2 of the 1997 Act, and submits that the petitioner has admitted that rent on and from the month of August 2021 is due and payable. First up, he submits that the petitioner did not deposit the admitted arrears of rent along with the application under section 7 within bracket 2 of the 1997 Act. First up, he further submits that the application, he therefore submits that on account of failure to deposit the admitted arrears of rent, the application under section 7 within bracket 2 was not maintainable in the eye of law. So paragraph, heard the learned advocates for the respective parties and peruse the materials placed. First up, in the application under section 7 within bracket 1 of the 1997 Act, the petitioner has specifically stated that the plaintiff number 2 used to accept rent in respect of the suit property, and lastly, the plaintiff number 2 accepted the rent on August 14, 2021 for a period of 3 months from May 2021 to July 2021. First up, it has been further stated in the said application that the plaintiffs did not accept, that thereafter the plaintiffs did not accept any rent. First up, the petitioner further stated in the said application that after a lapse of a year, the defendant requested the plaintiff number 2 several times to accept the the arrears of rent, but the plaintiff number 2 did not give a definite answer and delayed the matter. First up, thus from the statements made in the application under section 7 within bracket 1 of the after going through the statements made in the application under section 7 within bracket 2 of the 1997 Act, this court finds that it has been admitted that the plaintiff number 2 accepted rent for the last time up to the month of July 2021. First up, paragraph, on a conjoint reading of the statements made in the application under section 7 within bracket 1 and 7 within bracket 2 of the 1997 Act, it is evident that the petitioner admitted that rent from the month of August 2021 is due and payable from the tenant to the landlord. First up, section 7 within bracket 2 of the 1997 Act states that if in any suit referred to in subsection 1, there is any dispute as to the amount of rent payable by the tenant, the tenant shall, within the time specified in that section, deposit with the civil judge the amount admitted by him to be due from him, together with an application for determination of the rent payable. First up, it is only upon deposit of the admitted arrears of rent together with the application for determination of the rent payable, the learned civil judge is obliged to pass an order specifying the amount, comma, if any, comma, due from the tenant and, comma, thereupon, comma, the tenant shall, comma, within 1 month of the date of such order, comma, pay to the landlord the amount so specified in the said order. First a paragraph. The petitioner has admitted that the rent from the month of August 2021 is due and payable, is due from him. Full stop. Admittedly, the petitioner did not, it is not in dispute that the petitioner did not deposit the amount admitted by him to be due together with the application for determination of the rent, along with the application under section 7 within bracket 2 of the 1997 Act. First up, as rightly argued by Mr. Chatterjee, learned senior advocate, that unless the admitted amount, admitted arrears of rent is deposited together with the application under section 7 within bracket 2 of the 1997 Act, the learned civil judge is not under an obligation, is not under a statutory obligation to adjudicate the same and pass an order as contemplated under section 7 within bracket 2 of the 1997 Act. Full stop. Mr. Bonik, learned advocate appearing for the petitioner, would vehemently contend that since the learned trial judge permitted the petitioner to pay the current rent month by month, comma, the petitioner was not required to deposit the area rent. First up, this court is not inclined to accept such submission, as section 7 within bracket 1 within bracket A of the 1997 Act states that on a suit being instituted by the landlord for eviction on any of the grounds referred to in section 6, comma, the tenant shall, comma, subject to the provisions of subsection 2 of the section, pay to the landlord or deposit with the civil judge all arrears of rent, comma, calculated at the rate at which it was last paid and up to the end of the month previous to that in which the payment is made, together with interest at the rate of 10% per annum. Full stop. On a query of the court, Mr. Bonik, learned advocate appearing for the petitioner, comma, in his usual fairness, comma, submits that the petitioner did not raise any dispute as to the rate of rent or as to the period of default in the application under section 7 within bracket 2 of the 1997 Act. But the fact remains that the petitioner has admitted that the rent on and from the month of August 2021 was due from him, which was not deposited in compliance with either the provisions of section 7 within bracket 1 within bracket A, small a of the 1997 Act, or under section 7 within bracket 2 of the said Act. Full stop. Paragraph. Section 7 within bracket 3 of the 1997 Act states that if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein, or within such time or within such extended time as may be granted, comma, the civil judge shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. Full stop. In the order dated 14th of May 2024, the learned judge 12th bench, Civil Court of Calcutta, has specifically recorded that till the date of passing of such order, no rent control challenge have been submitted till date. Full stop. It is not the case of the petitioner that the petitioner submitted the submitted documents in support of their claim that the petitioner has complied with the provisions of section 7 within bracket 1 within bracket 7 within bracket 1 of the 1997 Act. full stop. Thus, the provisions of Section 7 within bracket 3 of the 1997 Act automatically stands attracted on failure of the petitioner to comply with the provisions under Section 7 within bracket 1 or 7 within bracket 2 of the 1997 Act. The learned trial judge was right in striking out the defense of the petitioner against delivery of possession. Full stop. Though the petitioner filed an application under Section 151 of the Code of Civil Procedure, praying for recall of the, where is that application?
That
151 for recall.
48, page 48.
Praying for recall of the order dated 14th of May 2024, but no document was filed by the petitioner in support of to show that the requirements of Section 7 within bracket 1 or 7 within bracket 2 has been complied with. Full stop. At this stage, it would be relevant to point out that on the prayer of the learned advocate for the petitioner, this court by an order dated 6th of May 2025 allowed the prayer of the petitioner to allowed the prayer for time made by the petitioner in order to produce the rent control challans for the period from August 2021 to March 2022 and November 2022 to February 2023 by filing a supplementary affidavit. Full stop. However, no supplementary affidavit in compliance with the order dated 6th of May 2025 has been filed by the petitioner. Full stop. Paragraph. The learned trial judge was right in refusing to recall the order dated 14th of May 2024. Full stop. Accordingly, now for all the reasons as aforesaid, this court is not inclined to interfere with the orders impugned. Accordingly, CO number circumcised stands dismissed. There shall be, however, no order as to cause. Urgent photostat certified copy.
Really grateful to Mal. Really grateful. Really grateful.
Item number 16.
No, this was that matter your lordship had directed us to take instructions.
Agreement entered?
No, not. Well, I don't want to hand up this paper. I have only jotted it down.
Give me the only the place and the time.
Yes. May I just hand this is my handwriting, lordship?
So consensus are arrived.
Yes, yes. That it's there, my lord.
Mandra?
This place is in Bandra, my lord, Mumbai. Lord, on
Geo World Drive.
It's a shopping mall.
It's Geo,
the company.
Geo World Drive, Bandra from 1:30 or 2 p.m. to 4 p.m.
Yes.
Yes, Mr. And the date is this Sunday.
This Sunday.
Sunday, 3rd August.
That'll be 3rd of August, my lord.
3rd of August, yes.
3rd of August.
No, Your Lordship, from 2 p.m. Your Lordship can fix the time.
It says 1:30 to 2. It may be flexible.
Yes.
Mr. Ghosh, half an hour. They will also have to travel. You will also have to travel.
I'm not saying that, but the duration of the meeting, that's him.
No, they have said from 1:30 to 2 to 4 p.m. They have said.
4 p.m. only because we'll have to journey back. I've checked.
You said that you will stay there.
We'll take a call, my lord. But whatever 4:30, 5 o'clock, I don't have any difficulty.
5 o'clock.
But Monday actually there's school. So if he could go back,
yes,
that would have been
that, Mr. Ghosh, you have to consider that.
But we'll stay till 4:30, whatever time your lordship decides to. I'll leave that to your lordship.
How much time it takes?
Takes about 5 hours. 4.5. I'm taking 5 to be on the safe side from Pune. If this were in Pune, that would have been the best for us. But we are willing to travel also, my lord.
5 will be 9 then. If it is 5, then 10 p.m. 5 hours. Can you prepone this time?
Yes.
From 12.
12:30, lordship, because it takes another 4 hours. I'll have to leave at 7 o'clock in the morning to reach.
It's also there. So I'm making it 1, Mr.
Lord, may I?
From 1 to 4. 1 to 4. Because the child also you have to consider the.
Lordship makes it approximately the 15 minutes here and there.
Yes. Mr. Bose, please ask your clients not to say that this time 15 minutes, this and there.
Makes it
After all,
Lord, but I was only beseeching one other thing, my lord. Because this process of visitation, my lord, is happening at the instance of the opposite party because it's their application of visitation. But with respect to the costs incurred for the travel, if they could reimburse me upon providing the receipts.
Mr. Banerjee says he will not be asked.
I know. I've had a word with Mr. Banerjee. I'm making the submission after consulting from the client. They will not have to pay whatever amount I ask for. They only reimburse the bills that I
What will be the estimated cost according to you?
will be
Mr. Ghosh,
approximately AC buses will take probably, my lord, it'll be around 2,000 rupees, max of 3,000 maximum. And that's what my estimation. I couldn't be completely wrong.
But they will produce evidence. You reimburse that.
Absolutely.
Mr. Banerjee said that.
I know. But the client's instruct. If your lordship disregards it, I don't have it. Mr. Banerjee said you take a chance. If the court is not agreeable, you don't insist on it.
I'm leaving it to Mr. Ghosh.
If they are disagreeable.
Your whole thing, Lord, your lordship can make it that it is sure that we can visit.
Yes.
No,
And are you? If both of you want any neutral person to remain there,
Grandparents
that will be a problem because who will go there? That's the problem.
Grandparents will go.
Those are the grandparents. Here locally we say special officer and other things. I think that is may not be necessary for the present.
Mumbai.
That will be a difficult thing. Or I can provide learned advocates on records of both sides.
We'd love to go to Bombay, my lord. We'd love to go to Bombay. If both the clients are paying.
Yes, Mr. Ghosh. If they want that.
No. My junior was saying, if we are kept at Taj, we'll happily go.
That will have to be, your client will have to be at.
Where's the expense? That is one place where we don't care about the client. Before your lordship starts dictating, one other thing. We are agreeable to this arrangement.
And Mr. Ghosh, only one thing. You have got now the recalling application. So next date is on your contempt application is coming up on 6th. So can you file the objection to that by 5th of August? Serve him a copy, give him an advance copy. I will direct also the recalling application to be taken up for hearing. Because you have got the recalling application. Yes. So do it one.
Lord, recalling application we agreed that yes, allow your lordship on our agreement, your lordship.
No. But recalling, I will allow it from here.
Not to praise the recalling application.
Yes. That so you I have given you liberty to file objection. So 6th the date is fixed. So you have to serve it one day before to them. Give an advance copy, maybe soft copy.
May I make one suggestion? Well, my recalling application, the one that I filed pursuant to your lordship's leave, that recalling application was pursuant to the order dated 4th of June, by which that entire direction of 48 hours, the visitation was given. If your lordship today is modifying that order, your lordship...
What order? No, I will only direct that report because recalling was rejected on the ground you did not comply with that.
Yes.
I will only direct that recalling application. I will permit them to file objection within the time. I will restore the recalling application to be taken up on that day.
So may I make one suggestion, just if they are agreeable, because we have already made that prayer in the recalling application. We are ready and willing this 2 hours, 4 hours. Lordship may make this the new pattern, modify the order that you asked recalling.
No, let that, because the report is there, court has to take into consideration.
No, that power your lordship has, my lord. 227.
Then
nothing remains in the recalling. We are agreeable. And lordship may make it every alternate.
Both of you agree. I do not agree.
Every alternate week we will do this. Every alternate weekend, like this weekend, next weekend we won't do it. The weekend after that, then that arrangement can take place.
What do you say to this?
Nothing
this arrangement? He says if it continues for a certain time, then both of you can apply for modification of that extension of other times.
Let us see what happens. Then we shall. Or your lordship make,
because otherwise that 48 hours, that question will remain.
What 48 hours?
That the child has to go to the father for a period of 48 hours in a resort. No. Then otherwise this arrangement.
Please see, there are two things. I do not know what will happen. Both of you are now agreeable. What will happen, nobody knows on Sunday. So then
No, then
I'll
be in contempt of that because I'll be in contempt of your lordship.
That is a different thing. So I will direct the recalling application. There you can make a modified prayer. You can make a submissions.
We've already
that is everything is there. Ashun. This application.
of July is page 115, my lord. I'm sorry, 110, 110.
Where is the operative part?
My lord, page number 113, last paragraph.
That's it, one.
113, the last paragraph.
Take up the hearing of such application on 6th of August 2025. Visitation,
So
Mr. Ghosh, there are two things. One is I have ensured prior to 6th. So you will be both of you, because I do not know what you will say, how many, because I have for tentative, I wanted something to be done. Father should meet for some hours. For that, I have made this arrangement. Both of you will be at liberty to make submissions with regard to visitation.
Yes.
Because I am giving that. The
But
parties will be at liberty.
Record uninterrupted, otherwise not.
Oh, yes.
Yes.
For that period, yes, that I will do.
Uninterrupted one, but that will, one.
See these type of matters, but these situations are to be tackled in a different way. Please advise your client accordingly. It's not a case of ego that you have to go and force. So you are the best person. Everything cannot be provided. It will go one way or the other.
But they are determined not to give visitors, and that is what they are.
Now they are. I think now they are there. Mr. Banerjee is there, and you are also here. I think that will happen. Please see, because after all, it's the.
Will ensure, my lord.
Please
Absolutely.
ensure that this is being done. What is that address?
The address of the mall, my lord.
Mr. Please give a copy. Mr. Ghosh, please check it. Address. Please verify. Give it, because thereafter do not say this is not the correct address.
There is only one Geo World in
Yes,
Mumbai.
please verify and give it to my officers. Address to likha debe.
I'm extremely grateful.
had only the lease deed, the
Yes.
plain opposition, and maybe some of the letters. With this much of volume.
Lord, kindly don't take me amiss. This does not, my lord, fall from, my lord, all the courts. Don't take me amiss. My lord, your lordship has done civil matters. I have also done some civil matters, my lord. Yes. All are not required. That is exactly why I did not place all the documents. But my lord, always, my lord, we are under the apprehension that, well, you have not annexed this. You have not. Where is this document? Now, that is exactly why I omitted to show a bunch of documents. There are the voluminous documents identical. Pay, no, I will not pay. Pay, I will not pay. That's it.
Yes. 145.
Yes.
You can place only that relevant part. What is their material defense?
Kindly come to my lord. Page 151.
Yes.
Yes. Subparagraph D speaks of COVID.
Yes.
Then subparagraph E. It is submitted that notwithstanding dire financial state of the defendant respondent on account of prevailing COVID-19 pandemic, the defendant respondent out of its goodwill and with a view to ease the financial burden upon the plaintiff, addressed an email dated 7th April 2020, attaching a letter of even date, informing the plaintiff that on account of the prevailing force majeure situation, the business of the defendant respondent had been severely affected. However, despite the same, the defendant respondent stated vide the said letter that it was willing to pay the plaintiff rent of 2% of the store's actual revenue net sales net of GST from 22nd March 2020 until further notice. The plaintiff was further informed that the rent paid in excess of 2% revenue for the period starting from March 22nd to 31st March would be recovered in future rentals. Thereafter, the plaintiff, instead of accepting the aforementioned act of generosity in a contractual matter, act of generosity on the part of the defendant respondent, addressed an email dated 9th April, Annexure C to the said application, disputing the contents of the defendant, later dated 7th April 2020, and further illegally stated that the defendant respondent is liable and obliged to pay rent for the lease period. In response to the defendant respondent with the email dated 18th April 2020 to the said application attaching letter dated such and such, apprise the plaintiff of the Government of India Office Memorandum bearing number such and such dated 19th February 2020, which categorically declared COVID-19 pandemic to be a force majeure event on account of it being a natural calamity. That is the difference. Nothing further. I can show your lordship, but my lord, I don't think that there is anything else. Now, my lord, as I have submitted today, my lord, don't go into all this, my lord, don't go into, my lord, the mean profit, etc., etc. Today, I say, my lord, I have given the calculation. Lordship will find, my lord, my client, I really do not know who prepared, not even interest added. Yes, normally, my lord, it is not done. No interest added in the chart which I handed over. Only the principal amount. And my lord, whatever payment, my lord, they have made and my lord have not returned by my client, my lord, I shall adjust that.
No, because the schedule says the statement, schedule of outstanding rent.
Yes.
And occupation charges at the admitted rate.
Absolutely.
Maybe from that interest has not been.
Yes.
It's only.
My lord, I will tell you, lordship, my lord. I will tell you, lordship, a story, my lord, not connected with this. I was moving an execution. I was, in fact, appeared in the arbitration also. The arbitration was in respect of, my lord, eviction of, my lord, Union of India from a property on Brabant Road, just, my lord, near Dalhousie Square. My lord, if your lordship remembers, my lord, it was the old
passport office, my lord, the building where the passport office was, that is the building. It's a Bengali, till date, my lord, it's a Bengali, my lord, company, or company owned by Bengalis. Now, my lord, there, my lord, the Union of India or my lord, CGST office was occupying about, my lord, 8,000 square feet area. Eviction, mean profit. When the mean profit was shown to be the claim, it was at the rate of 65 rupees per square feet. I only said that it's because you are a Bengali, that is why this is 65 rupees. Had it been anybody else, it would have been 650 rupees and they would have proved that. No, sir, we cannot do that, sir. Very well. Be happy with that. Now, no interest here. Be that as it may. Today I say that, pilot, please, pilot, they are carrying on business. It's not their case that they are not carrying on business. They are roading businesses running from there. And I am being deprived. I was, my lord, humbly submitting for the time being, my lord, this money may be paid and, my lord.
Any decisions you wanted to rely upon?
No, not really. I did not, my lord, come up with any decision for this, my lord, that at payment of admitted amount. If your lordship is pleased to look into, my lord, the CPC or Order 13A, well, it is very clear. Yes. Well, scope and classes of suits, my lord, Order 13A, Rule 1, stage of the application, my lord, that, my lord, the court held that I am within that stage. 3 kindly come to, the court may give a summary judgment against a plaintiff or defendant on a claim if it considers that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim, as the case may be. Now, my lord, as I have
has been quoted by the learned judge.
Now, my lord, payment of money, my lord, again, the admitted amount, amount or the rate mentioned in the list. I'm seeking that only. Well,
Yes.
those my
Yes.
Yes. Later on, my lord, it would be decided, my lord, can be sent back, my lord, about the decree for eviction. Today, my lord, I am seeking before your lordship, my lord, this
Decree for eviction has to be there because
so these are the 2 points, my lord. It can be decided in Order 13A. It can be that.
yes, but for that also it has to be remitted, not by this
Just
court.
reject it.
Yes,
no.
that
I say, my lord, that kindly, my lord, let them pay this money,
Yes.
admitted amount for the time being, and my lord, send it back.
yes.
Remand before the court below.
Yes.
এত বাজে বকেছি
Yes. Please adjust your microphone. Yes.
I just take the trouble of taking a lordship through order.
I'm making 5 minutes.
Lordship order. This order sets out the procedure by which courts decided to for commercial dispute without recording oral records. Now, suppose that the person has no real prospect of succeeding on the claim successfully
Here, Mr. Mitra is urging that the defendant has no,
I understand, my lord. I would like to defend that, the grant July first, that is good. Shall we? This is a property of ground first on second floor around the business lordship wood. Tree or some stop and
for the moment, accept that. Now, you are still occupying.
Lordship, I am occupying.
And after the COVID is long over,
I am paying him.
Great.
I am paying 6 lakhs. That is
from when? From when?
From after the COVID restriction.
From when? Please tell me from when you have been paying 26 lakhs 50,000.
Lordship, the last I will the last I am aware that we are the exact from this I am I will take instruction at this
that is a different thing altogether. I want to know from which date you are paying.
I will
because your defense is only COVID. So COVID, one may say it's not still over, it's been going on, but the thing is that everything has been normalized. I think from March or April 2022, this judgment is March 2022. So from March 2022, what have you done? Let us for the moment keep aside that COVID period. From March 2022 or April 2022, whatever the case might be, what have you done? How much have you paid? Whatever you have paid, adjustment can be made. So that's Mr. Mitro's submission. But he says that he has given checks returned. If you have encashed, well and good, then you cannot get any adjustment. If you have not encashed, Mr. Mitro submits that yes, you will be entitled to those adjustments. But my view is, since when you are paying
instructions in that regard, then this matter instructions.
And what is the amount from which period till which period you have paid at what rate?
I'll take instructions. I'll take instructions.
And also, during the COVID period, look, there are two things. As Mr. Mitro has rightly said, maybe for the COVID, you may not be in a position, let us accept for the present, that you are not in a position to pay at that rate for that period.
Lordship, that amount that at 6 lakhs, you are not earning that amount at that point of time.
Take your case for the moment. I'm not saying why did you not pay. Let us accept that for that period you could not pay at that rate, but you volunteered to pay at some rate according to your own calculation.
Sure.
But as rightly pointed out Mr. Mitro, is that under various statutes, those extensions, it's not that complete waiver, extension of time. Let us assume, yes, you could not pay for ABC reasons or for COVID, not ABC reasons, for COVID. Then you might be entitled to an extension. So that is long over from April 2022. Today we are in August 2025.
Things opened up, my lord, long before that.
But but those
I can also, my lord, give an example here. That my lord, from I still remember 16th March 2020, we had, my lord, a meeting in the library that there is something which is known as COVID. None of us was my lord, wearing this mask. We said that there is something called COVID. So the court, we shall keep the library closed for 7 days. Now we started smiling that every year we have a new ground. Either the judge is not there or the facility is not there. So we have additional holidays of 7 days. Now this is a new ploy. Very good. 7 days. I never expected that this will turn out to be this. But I can tell your lordship this much, my lord, for the initial months, my lord, I can be, my lord, a senior. In the juniors, we did not have any income, but we had all the expenses. All the expenses.
That is,
I felt for juniors, my lord.
yes.
We could, my lord, survive, my lord. I could have survived, my
Yes,
lord.
but
It was
Mr. Mitro, at that point of time, everybody was in deep trouble.
Absolutely.
So everybody was in deep trouble. So let us assume so till, because extensions and other things were granted by the courts taking account of those. So last extension was for all those statutory compliances was, I think, till March of 2022. Let us, but even if that is accepted, even if the extension is being granted, so more than 3 years have expired. Because that is what Mr. Mitro's endeavor is, that you are enjoying without paying anything.
Lordship, I'll just indicate one thing. Lordship, the written statement and exclude this civil. I just hand over a copy of the written statement.
It's not on record.
It's not on record. Don't place it. On record, acceptance is a different thing altogether. If
I just want
accepted,
I just want to use a document that we have relied on.
only one thing
I just indicate.
that I am not that serious that it is to be on by way of an affidavit. If it is a part of the record, maybe you have rightly said it's part of the record, but unless it is accepted, I cannot look into that. That's the difficulty. So this is not the stage where that is to be looked into. Yes, what is
Lordship, the December 2020, in fact, according to the calculations, it became a gross amount of 26,53,000, which is more than the rent that is in the agreement.
all right?
Lordship.
Mr. Mitro says that yes, please make a calculation. You can take instructions. I'm keeping it on another day.
I'll come back.
So what are the payments made? But please give with supporting documents so that you can give it beforehand to Mr. Mitro's learned advocate on record, because they also have to verify. And Mr. Mitro, I will direct Mr. Mitro's advocate on record to supply this statement to you so that
I have given.
I have.
you have got.
I have.
So you give share your calculation, what you have paid with those particulars, if you have credited it to the bank account or by way of check, because whether they have actually got the benefit of that amount, that is to be, even if accepting that you have paid something more than the contractual rate. Mr. Mitro says you will be entitled to that adjustment also.
But then contractual rate.
That is what he is saying.
I will be happy with the contractual rate.
No, he says for some month he has paid in excess. Even if that is accepted, you have said everything, all payments, you will be getting adjusted. So no difficulty on that.
I cannot deny that.
Yes, he is saying that yes, if for 1 or 2 months or some months you have paid in excess of the contractual rate, you will be entitled to that adjustment. Make a calculation, share it. How much time you require for that?
Lordship,
And also take instructions. Maybe
I will take instructions.
after you take these instructions, according to you, you may say that yes, X amount is due. So admittedly from you, how much time you will pay that admitted amount? Admitted. Then other things I will consider.
I'll come back with instructions.
It's not on record. I have not stated that. Possibly I have not stated. So all India company doing marketing all over India. It's not, it's a chain. It's a chain like, my lord, other things by we know Spencer, etc. It's like that. They have existence, all of the offices not here in Calcutta. There.
Yes, let him take instructions, because Mr. Mitra, for the present, you want the contractual rate for that period.
And send it back.
For that period.
Remind it back.
If he shows something that he has paid And you have said that
I've
you
said
have
that.
you will be giving adjustment.
Cannot deny.
So let him come with the calculation. Please also you verify from your accounts.
Absolutely.
Sure, I will just take one. I will can fixed on so that I have one.
You can take 1 or 2 days more
but
because please give a calculation.
না টিউসডে রাখতে বলছো
No, please, I can give you 1 or 2 days more. That's not a problem because when you can give this calculation to them, because they cannot right now say, because also they have to take instructions. When you can share this information of that calculation to Mr. Mitro's learned advocate on record, when?
If they give it on Monday, kindly keep it on Wednesday. I shall verify it in my lord.
When?
I will keep it on Wednesday.
By Monday, we will be giving to them.
By my lord.
Frank, say what is the expected? I think Mr. Mitro will not oppose that. 1 or 2 days here and there, Mr. Mitro will, because Ashun.
Then kindly keep it on Thursday. If they give it on Tuesday, my lord.
Yes, I will give you some time. I am also giving 1 or 2
Yes,
days more to him because
I am not.
being that you are appearing on your his other side, he must be saying that yes, 1 or 2 days he is thinking that yes, Ashun. Take if there is any admitted amount due. Dispute I will consider. Admitted amount, so you have to come with something that within a short time, how we will pay that.
I will.
Yes. Yes, call the next matter.
Next assigned matter Item number 149.
I appear for the response number 10.
Lord, I am for the petitioner. My lord,
What requiring body?
my lord, I'll tell your lordship. My lord, this matter is, my lord, regarding, my lord, land acquisition proceeding. My lord, the section 4 and section 6.
Why it has been assigned?
Lordship has heard Mr. Mukherjee, my lord. I am led by Mr. Shoktinath Mukherjee, my lord, on a number of occasions. My lord, he is leading me in the matter. My lord, I am only, my lord, praying. My lord, today
Only difficulty is when it will be taken up. That is why.
My lord, I believe, my lord, it is my firm belief that that matter will not take long. My lord, I am only praying, my lord, lordship knows, my lord, Mr. Mukherjee, my lord, any day, my lord, in the first half, my lord, second half, it gets a little difficult.
First up,
Any day.
motions is the problem. That is.
My lord,
that
maybe
is-
at 12:30, my lord, if it comments to your lordship, I leave it to your lordship.
Lordship,
But
I was-
prayer, my lord, because of his health issues. Are not
No, that I appreciate, fully appreciate, but only difficulty is.
Lordship, we have no difficulty. Only, Lordship, I am being led by Mr. Ratnanko Banerjee. I believe he is there online, but even if he is not there, your
name
Lordship,
is there, but he is,
yes.
yes.
But nothing survives in this writ petition because the acquisition proceeding which has been challenged, we have got the compensation.
My lord,
Nothing survives. It has become
question is, my lord, the
surplus.
not of the compensation.
Anyway.
My lord, this acquisition proceeding, my lord, in another, my lord, matter, the same section,
yes,
section has been, my lord, already.
And another thing is that, according to him, the acquisition proceedings has been set aside in another proceeding.
Same, my lord, notice.
Not in, yes, same notice.
Self-same notice.
That has been set aside.
Different land. Anyways, let him
It
argue
covers
that.
those, all the Dagna.
All this, so that notification itself has gone.
So we will argue on that, your Lordship.
Very well, my lord.
Yes.
Praying.
Yes. No, the notification itself has gone. That's what I thought, Malad. I don't know what Malad, the
That
argument is all about. And I've received, Malad, my whatever money I had put in, Malad, I'd also received back the money.
That is a different thing altogether, that you have received money, but if the acquisition goes, what will be the effect of that? That's the, and the only difficulty is when to be taken up. Because these are the assigned matters. I was thinking if I can, you can try your luck before the regular bench.
My lord, my lord, we have, my lord, lordship has heard this matter, my lord, truly, my lord, in this case, my lord, lordship has heard it substantially, my lord. This is my respectful submission. Mr. Mukherjee, my lord, I may be, my lord, another
Only
day or two,
thing
my
is
lord, the
that
matter
these
can
are
be closed.
assigned matters and it is difficult for me to take up because after many days I have fixed this for today.
My lord.
That's the only difficulty.
I completely appreciate, my lord, I bow down. My lord, my only prayer is, my lord, keeps it at any day. Preferably in the first half, if not, my lord, my lord, whenever my lord, lordship feels, my lord, kindly keeps it, my lord, perhaps in a day or two, my lord, maximum 1 or 2 days, my lord, it can be closed. Well, that is my belief, my lord. I am expressing it.
Once he finishes, then Mr. Banerjee will make submission.
Yes, Malad, we'll make our submissions after that.
How much time Mr. Mukherjee will take?
Well, maybe a day, maximum.
Entire day.
My lord, I mean to say, well, one instance of one appearance of an instance.
That is the difficult thing to keep it. That is why from goes difficult for me to manage the list. That's the difficulty.
My lord, I completely appreciate.
But Malad, before Malad, this matter is taken up completely, Malad will also consider Malad the effect of that quashing. Malad will take up Malad that effect of.
That is the only legal issue, Mr. Banerjee.
Malad, if the proceedings have already been Malad quashed, Malad acquisition, then Malad, I don't know what survives. But anyway, Malad,
So that's the Mr. Mukherjee's argument. So if the notification, he wants that. If I now faintly recollect, he says that when the notification has been set aside at the instance of another company or something.
Yes, Kanishka Engineering, yes.
Is in respect of a different plot, but within the same notification.
Well, the process becomes none in the eye of law.
Process is null and void, or what Mr. Mukherjee has argued in that line.
That is
So the entire thing is null and void. That was what was Mr. Mukherjee's submission.
Yes. Lord, I only pray, my lord.
Mr. Mukherjee is not available in the second half on any day.
He may be, my lord. Only thing is because of lordship knows, but I don't want to say it. But first half is better for him.
All right.
I
give it to your lord.
Any day, my lord, convenient to my lord.
Mr. Banerjee, I'm not fixing a date now because I have to consider when to.
Very well, my lord, very well.
So I can do one thing that will be indicated 2-3 days prior to that. When
very well, very grateful, my lord, grateful.
I'm most grateful.
ওটাকে একটুখানি করে দেবেন মানে এই অ্যাসাইন ম্যাটারটা যেদিন হবে একটু আগে কিন্তু ইন্ডিকেট করে দিতে হবে আসুন Heard Mr. Dotto, learned advocate for the petitioner, and Mr. Banerjee, learned senior advocate for the opposite, for the respondent number?
10.
For the respondent number 10. State is, where is the state?
State is.
I indicate the order to it.
None appears for the state. First up, paragraph. The hearing of the matter, for the ends of justice, the hearing of the matter stands adjourned for the day. Yes.
I'm grateful, my lord. I'm extremely grateful. Mr. Mukherjee is.
Mr. Mukherjee has joined.
I think he.
So yes, Mr.
My lord, perhaps he thought the matter is going on.
Yes, Mr. Mukherjee.
My lord, I am appearing for the petition, my lord.
Yes, yes.
The difficulty is Mr. Dutt, my son junior, he
Yes.
missed the matter. The records are with him.
Yes.
I have to produce the records. I won't take more than 15, 20 minutes.
But Mr. Mukherjee, your junior told me that you will be taking one entire day.
Yes, a wrong impression, my lord. I do not have that kind of stamina. But in this matter, I will speak for the whole day.
Mr. Mukherjee, what time will be convenient for you?
In the morning, my lord, it will be convenient.
Mr. Mukherjee, only thing is that this will be indicated because this group, I will indicate 2-3 days prior when the next date. Because today, readily fix a date next date. That's
in the earlier part of the day will be convenient for me, my lord.
Yes, I will be. You want in the first half?
First half.
Yes, I will consider that.
Grateful, Lord.
Thank you, Mr. Mukherjee. अच्छा चलो ওটা না Mr. দত্ত না লিখে Mr. Mukherjee লিখবেন Mr. Mukherjee learned senior advocate assisted by Mr. Dotto appears for the petitioner আর যেগুলো আছে hearing of the state is not represented hearing of for the ends of justice the hearing of the matter stands adjourned for the day.
Instance বলেছি, I never meant the whole day.
Yes.
Very well. But I meant, my lord, only one instance, not the whole day.
I thought he was asking for an entire day.
My lord, one
Yes, he
instance.
told
One
that.
instance. But
One entire day
it was,
he told.
way it was put was not correct. Well, I meant one instance. Grateful.
Yes, thank you. Yes.
Senior.
Yes, call the next matter.
Item number 150.
I'm appearing for the respondent.
I'm appearing for the petitioner.
Yes.
One humble request.
What?
150 and 151.
150 and 150.
That is CO 15561 and 1574.
All right.
Your Lordship, if I am being permitted.
Yes.
The order which has been challenged, that is 15th February.
Oh, this is that matter to civil division application or civil division applications were disposed of. Yes. Now, what are the orders under challenge here?
The order which has been passed, there is a question of functus officio because that order which has been passed by overruling the predecessor judge of which I have annexed in the page number.
Show me the impugned order. What is the order under challenge?
Yes, Lordship. That is in the page number. February.
All right, give me a minute. Take your seat.
Yeah. Petition.
Yes. Yes.
Your Lordship, this is having two limbs of the entire case. First, they have all together, they have claimed that they are the owner of the property. And not only that, in the injunction which has been passed by the Honorable District Judge in 2012, after that, they have violated the injunction. And I am being deprived of the injustice. Why I am telling? Because this is the certified copy of their written statement in the injunction, that they claim the property. They are the owner of the property. Which
Where is your plaint? Where is the plaint of this suit?
Suit.
Where is the plaint? Where is the plaint? You have filed a suit. Where is the plaint?
That I have not annexed, Your Lordship.
No, do you have a copy of the plaint?
Right now, I don't have. But
Yes.
what I am like to summarize, that they have all together claimed that they are the owner of the property, because I have purchased in 1996, and from all together it is mutated and tax-paid property. But they are telling, after this filing of the injunction, there are several judgments of the Honorable Supreme Court that this cannot be violated, this injunction. But what they have done, they have claimed that they are the owner of the property, and they have taken a corporation municipal sanction plan, and they have built up a house without having the land title, and they have sold 16 flats in 2016. And not only that, they have offered me a flat which I have already I am placing. This is the certified this affidavit which I am placing.
No, that was not considered. Certified copy, what are the documents you are annexing? I cannot take up new documents which were not part of the appellate court.
Your Lordship.
Were this part of the appellate court's document?
Your Lordship.
These were part.
These are the part.
Yes. Yes.
They have
this is written objection to Order 6, Rule 17.
That they are telling that they are the owner of the property.
No, that is, now we are on the injunction, miscellaneous
Yes,
appeal. So the scope is only with regard to that. Please make submissions only with regard to miscellaneous appeal, this order.
Yes, Lord.
Because other things, Order 6, Rule 17 and other things, I cannot go into that now.
No, I am telling that the injunction which what the Learned District Judge has quoted.
Yes.
That in the last page, that is page number 3, with regard to the facts and circumstances of the case, considering the prima facie as well as the urgency in the matter, let prayer for the
Which page you are placing?
Page number 16.
Page number 16.
No, here I am placing this, Lordship.
No. From the impugned order. What is from the impugned order? Show me how what is the infirmity in the order impugned. Please show me from the impugned order, 15th
Now
of
I
February
am
2023.
coming on that particular point.
Yes. What is the suit you have filed? You are the plaintiff.
I am the plaintiff. I
What
am
is the suit for?
Suit for the that it was my land and my wife's land. It is 4 katta, few chotak, and they have constructed the house where for this district judge has Learned District Judge has given the injunction, and from 2012 it was continued. And initially, I have already annexed one.
Show me the order where the Learned District Judge has given injunction. Where is that?
Yes. Page number 32 and 33.
32 and 33.
Order number 46.
32 and 33 is the order passed in the criminal revision application.
No, before that. It's not matching.
Lord, may I assist your Lordship?
Yes.
Yes. So the fact is that it was a suit for declaration and permanent injunction, which was filed by him and his wife against my client before Learned Alipur Court. The injunction application at the Civil Judge Junior Division was rejected. He goes on in an appeal. Status quo granted. Suit in 2012. Suit for declaration and permanent injunction. The plaintiff.
Declaration of the title.
Right. Now
the status quo order was passed by the appellate court, by the district judge.
The 7th. Now, your lordship kindly comes to.
Status quo was ad interim or temporary?
Temporary, your lordship.
Temporary.
Then it was
Let
heard
me-
in,
let
then,
me
then it was
complete.
heard in finality on 15th of February 2023. Your lordship kindly comes to the order he has annexed.
Yes.
After 1 or 2 pages, his pagination is, if your lordship kindly finds.
Your lordship, should I complete so that he can?
Call it. Yes.
The order which has been passed by the predecessor judge annexing the 3 deeds what they have should hold. But the question remains, the honorable judge on order number 46 in page number 26, order number 46. That is a predecessor judge of
Order number, page number
26. 26, 27, 28.
It's not matching, sir.
My lord kindly comes to the impugned order. That is absolutely
Not
clear.
matching, and you have annexed only the orders passed in criminal motion.
No,
Criminal
before that the order is there.
Order number?
Order number 46, your lord.
Yes, I've got that. That is at page 34.
Okay.
Yes.
Not. I have already heard the learned advocate of the both sides in the second para.
Yes.
Regard to the application, I carefully perused the instant application filed by the respondent petition for objection of the sale during the pendency of the suit. That is 27/3/2018. And on behalf of the appellant, I also perused the other materials on record. It appears that the appellant preferred this appeal, aggrieved by the dissatisfied with the rejection of the prayer of interim injunction. Learned trial court passed the title suit 158 of 2012, vide order number 4/3/2012. And it further appears that the present appeal in application was filed by the appellant under section 39(1) and 2, read with 151 CPC, against the respondent praying for temporary and interim injunction, vide order number 2. Letter 10/5/2012, district judge has been pleased to pass an interim injunction order in favor of the appellant in the following manner. Let the prayer ad interim injunction is granted in the form of the status quo. Respondents are hereby directed to maintain status quo in respect of the nature and character of the suit property as well as title and possession of the same till 1/6/2012, and thereafter this injunction which has been. Now I come to the straight part in the last para, that no partition, sale or deed agreement during the pendency of the suit is valid according to the provision of section 52 of the Transfer of Property Act. It further submitted that instead of objection, that if the respondent without permission of the original owner constructed and transferred and alienate the flats. This is the vital points learned judge has passed. Because they have constructed the house without having land title. Without having land title. And they have to disclose the name of the purchaser. They have not, because they have constructed the house. Even they have offered me a flat in writing. And for that I have already given a supplementary affidavit, which I want to place, if your lordship permits.
Let me see.
Okay. And thereafter, considering the instant application, objection dated 27/2018, other materials on record, I find that the respondent dismissal of the instant appeal on the ground that during pendency of the instant appeal, the appellant transferred the suit property. registered deed of conveyance. The respondent files the Xerox copy of the certified copies of the deed. And now I come to the last part in the order, that the instant application.
So you have transferred the property?
Yes.
To whom?
To me. Because there is a.
To whom?
That is the respondent. Why I am telling? Because they have already constructed without having land title. And for that, police of the Purva Jadavpur PS filed the charge sheet.
No, now, yes, accepted. So according to you, they have made a construction on your property without having any title.
Land title.
Without having land title. But in the meantime, you have transferred it to them.
Not that. It is after filing the charge sheet 80 days after that.
All right, whatever may it be.
Yes.
Now the position remains that you have transferred. Now you have no title at all in the respect of the
Dear
property.
Lordship.
See, you have at presently, you do not have any title in respect of the property. What remains in the suit? Sir, what remains in the suit?
Your Lordship, these
My lord, just
these
come to
part,
the impugned order.
these part which has been taken.
Sir, please, you are, I think I could not make myself clear.
Dear Lordship.
Now, you filed a suit claiming title. Now, at that point of time, you had title. Now, after you have transferred it to them, you do not have any title. Now, what will be declared now? You have filed a suit for declaration of your title.
Your Lordship, I bow down. I am placing only two things. Number one, they have also claimed that it is their property. They have constructed the house which has been rejected by the learned predecessor.
What remains now to be decided?
The decision that has to be decided, what I am placing, Your Lordship, when the charge sheet which has been filed.
Charge sheet will proceed. I am not interfering with the charge sheet.
Because
Let
charge
the
sheet is
charge
related
sheet to proceed on its own way. But now what remains, because you have filed, sir, please understand this. You have filed a civil suit for declaration of your title. Because according to you, you are the owner of the property.
Your Lordship.
So you approached the court for declaration of your title, and your allegation was that they have made construction upon your property without having any title.
Yes.
But the fact remains that in the meantime, during the pendency of the suit, you have transferred the property in their favor.
Your Lordship, there is several judgment of the Supreme Court which I can place it before you, that in the injunction period, if the injunction has not been vacated, they cannot transfer. What?
But you have transferred, sir.
I have transferred, but that why I have transferred? Because they have already sold the property.
Whatever may be the reason.
Twice it
Whatever
cannot
may
be
be the reason.
transferred.
So there are two aspects. One is they have transferred means according to you, they're in violation of the order of injunction, they have transferred.
Your Lord.
So proceed under for violation. Nobody is stopping you from that. But with regard to the suit, what remains? Because this is against an order of injunction. If you don't have title in at present, what injunction you are entitled to now?
No, that
maybe you are right. You are right that there was an order of injunction they could not have transferred. You are right. But proceed against them for violation of the injunction.
That I have asked for several times because I have already.
But that is not the subject matter in this. Proceed with that. I'm not stopping you.
But my humble submission, because they have sold the property to the flat owners. Even they have offered me a flat that will establish.
I accept
and what
that.
happens with me?
But that is not the subject matter of this civil revision application. This civil revision application arises out of an order passed by the district judge rejecting this your miscellaneous appeal, holding that you have transferred the property, so you are not entitled to injunction. So it was vacated by this order of 15th of February. Till then, there was an order of injunction. Till then, there was an order of injunction. According to you, in violation of that, they have transferred.
They have transferred to whom? They have transferred to the flat owners.
Yes, yes.
That. And what remains with me? I was compelled to sell those flats because otherwise I have lost both the hands.
I appreciate that. For violation, there are two aspects. For violation of that injunction application, you can proceed. Have you filed any violation application? Order 39 Rule 2, have you filed any application?
Yes, Lordship.
Let that proceed.
That thing also not being considered by the learned 730.
No. Where is that? Order 39 Rule 2 pending. What is the miscellaneous case number?
That is 13. order that is 13, which I have in the 1974 CO, it is a certified copy which are there. Because I have filed that 340 rate with 195, they have violated.
Not 340, what 195. You have to apply under Order 39 Rule 2A. That you have not done.
Your Lordship, they have given the false affidavit. They have done the entire.
You proceed with that. Nobody is stopping you from that.
No, they
But
have
here-
also quashed that. 340 also quashed.
That is not under challenge now. The challenge is with regard to
It is
the
also
order
challenged
dated.
in the 1974, your Lordship, CO.
All right, 1974, I will come. 1561. So it's the order of, it's the appellate order of injunction.
Your Lordship.
What remains in this when you have transferred this?
Lordship, that is the particular pertinent point that I do not have two hands in my own property because they have constructed, they have sold. Number one. Then I was compelled that if I have not sold, then nothing remains with me. And there are several judgments, just I am quoting. I am just quoting.
Yes.
This is a division bench judgment.
Yes.
Of Mosumi Bhattacharya, previously in Calcutta High Court, now in Telangana, division bench judgment, where it has been categorically told that by citing the Supreme Court judgment, that when the injunction is there, any transfer is null and void. And not only that, your Lordship, I am just citing, there are several Supreme Court judgments.
Yes.
Should I just give the reference of the Supreme Court judgment?
Yes.
Century Flour Mills.
Madras.
Madras.
Madras High Court judgment.
Your Lordship. Full bench judgment.
Yes.
An act is done in violation of an order of injunction to settle.
Give me the reference of the Madras High Court judgment. 72 Madras.
Yes.
Yeah, 1972 Madras.
Your Lordship.
Please give me the page number.
Page number is 66. An act is done in violation of an order of injunction to set the wrong right, perpetuation of wrongdoing. Now, second judgment which I am placing, that is Sujit Pal versus, that is of Calcutta High Court.
Yeah, 86 Calcutta.
Yeah,
86 Calcutta 220.
220.
Thank you.
In page number 14,
yes,
the plaintiff in violation of the injunction, the defendant in violation of the injunction took possession of the property. Now I am just telling another, that is the Supreme Court judgment of Jehal Tati and Nageshwar Singh, page number 6, which has been
reference
G.S. Singhvi, Honorable
no,
Justice.
reference of the Supreme Court judgment.
Number is not here. I'm sorry, but if you Lordship permit, I will
yes,
place this judgment.
Yes.
Since the sale deed was executed in favor of the respondent in the teeth of the order of injunction passed by the appellant court, same appear unlawful. So, if you tell me that I will give the another few judgment of the Supreme Court where it has been categorically told that during the pendency of the injunction, whoever might be the violated the injunction, that cannot stand. That is my humble submission, Your Lordship. And they have given, this is the, which I have already annexed, they have given the offering of the flat. They have constructed the flat. 16 flat they have sold in where the trust property was, property was not with their, in their title. And police has filed the charge sheet, 2 charge sheets. That is one of myself and one of my wife. So that proves that they have violated not only the injunction, they have violated the title of the plaintiff property. So that is my all submission.
Lordship, I will speak from record only. If your Lordship kindly comes to the impugned order. It's
Sir, he's appearing in person. Don't say these things. He's appearing in person.
no, I'm just reading the impugned order.
Yes, yes.
That will be because it's over there.
Yes. Do you have the copy of the plaint?
I can give you one.
Please give me the copy of the plaint.
I don't have a copy of the plaint, my lord. I'm extremely sorry, but I'm just giving you a copy which he has served upon me. I've just folded it, so I'm just handing it over.
Can you give me the copy of the plaint? Because those are not here. I want the copy
I'm
of the
having,
plaint.
but right now I do not have in the file, but I am having, if you Lordship permit,
Copy of
I can produce the copy of the plaint also.
Yes.
That is okay, but I'm just reading the portion of the impugned order. It's after one or three pages.
Yes, sir, you can take back this. This was the original certified copy.
Lordship, first of all, I would like to point that the impugned order, if your Lordship kindly takes impugned order, I think it's after 2 pages.
Sir, only one thing. If you have purchased it from him, admittedly, you did not have the title when you have constructed.
He sold me in 2017. After I constructed after that. Let us come to the impugned order, it will be clear because
You have constructed after that.
No, Lordship.
Absolutely.
Yes.
Yes.
Show me from the impugned order.
So, I'm just reading the decision with reasons. Considered the submissions of the parties, the documents filed by the parties, impugned order passed by the learned trial court, orders passed by the Honorable Court and various materials on record. It appears that the Honorable Calcutta High Court in a writ petition filed by the appellant challenging the sanction of a building plan in respect of such premises by an order dated 12th of March 2018 has been pleased to observe that in view of the petitioner no longer being the owner of the immovable property concerned, it would not be prudent to look into the grievances of sanction of a building plan in respect of such premises. This is observation of this Honorable High Court in another writ petition.
Sanction plan.
Very yes, sir. Considering the 3 registered sale deeds which the appellant plaintiff has executed in favor of Messrs. Nortec Property Private Limited. Now, this Nortec Property Private Limited are the defendants. With the present respondents being the director of the said company, it appears that the scheduled properties described in the 3 registered sale deeds form part of the scheduled property as described in the plaint, and the same has been transferred in favor of the respondents, and therefore the appellant plaintiff has prima facie no right title interest and possession over the suit property. It is also significant that the appellant plaintiff and his wife have also handed over the original registered sale deeds and certified copy of the sale deed to the respondent, that is me, which they received from the custody of the court, criminal court, by furnishing Zimmanama. So he furnishes everything to the criminal court when the police seizes it. He takes everything by way of Zimmanama. He comes and sells it to me and he wants this suit to proceed. Therefore, considering the aforesaid aspect of the matter, I am of the view that the purpose for which the instant miscellaneous appeal has been filed has become infructuous due to transfer of title and ownership of the scheduled property in question in favor of Mrs. Nortec Property Private Limited, of which the respondent are directors. In the result, the instant miscellaneous appeal.
What is the stage of the suit now?
Now, what happened? Another CO was filed by him, where after this order, we filed a section 151 application for dismissal of the suit over in the learned trial court. That was being dragged. And ultimately, your lordship was pleased to pass this order. This is your lordship's order.
Yes.
It was taken up with another CO filed by him. And in that, your lordship has been pleased to direct that section 151
to be disposed of expeditiously.
Yes, within 8 weeks. So that is pending in the learned trial court. And as per your lordship's order, that will be disposed of within 8 weeks.
The suit is otherwise ready for hearing. What is that stage of the suit?
Issues have not been framed yet. So
they have filed a written you have filed a written statement.
Everything has been done. So on the basis of this order, and these are the 3 deeds we had filed over there. For 40 lakhs, he sold me the entire property for 40 lakhs. And still he is continuing with the...
When these transfers were made?
2017.
And what was the date of your sanction plan?
14.
I have to
That is the
I have to
question.
check that.
No. That is the point.
I have to check that. But during the pendency of this suit in 2012, he sold me the entire thing. And now he's coming up and saying that no, this is an illegal thing. These all things were placed before
All
the
right.
trial.
So according to you, since he has transferred the property, so there is nothing left in
Nothing
the.
left in the suit, my lord.
Yes, and what is the other civil division
That's
application?
the same.
Same.
Filed by his wife.
Oh, acha, acha.
Husband and wife.
Same.
Same.
Ashun. Heard the learned advocates, heard the petitioner appearing in person and the learned advocate for the opposite party. Hearing stands concluded, judgment stands reserved. Yes. Yes, call the fixed matter. না 150 না 3.5 একটা ছিল না 3.5 ফিক্সড আছে
For orders that matter, my lord, what you had fixed.
What happened?
I fractured my wrist.
Fell down?
No, my lord, taking the baggage from the belt. My hand turned. হ্যাঁ তুমি তো বলবি আরো বেশি করে বলো।
Yes, Mr. Mitro, which matter?
154 man. Reimposition of
Reimposition of interim order. 154.
I can come
Next.
back.
Yes. When do you want?
At least I can leave them.
Yes. That Mr. Banerjee can assure you only.
But I'm only waiting for the order.
Small briefs, man.
এই আবার
Yes.
Yes, I was, Malod, only the order has to be given, Malod. That is
What
all.
order? No. Junior has not.
She wanted to ask something from me.
Yes,
Yes.
because Mr. Banerjee, I think it has also went. There were two facilities. One overdraft and another is term loan. No, working capital term loan.
Yeah, yes, emergency credit line.
Yes. So you have given me but she says this is not the. You told me that this is the overdraft facility.
Account. The statements I've given. I'll show it once.
He's saying no. That
Only
is why.
one account has been closed. Another account is still continuing, my lord, because there is NPA, my lord. But
Then, Malod, he is making it more complicated because his proceeding is against both the accounts.
Yes.
So he has to then bifurcate this initiation of the proceedings on the. We cannot speak together, Malod. This initiation of proceedings, then, Malod, on the face of it is bad. There has to be a bifurcation.
Consider where are those?
Yes, Malod, I showed the statements. Kindly comes to page 79.
Yes. Yes, so I'm fixing it because this is the thing.
No, but my lord, she told what they have done. What they have done, my lord. Obviously, this is the reason I came before my lord. 1st of August. Today they have published it. They should not give effect to this at least. Keeps it tomorrow. Keeps it on Monday.
Not maintainable, my lord.
That is different.
No,
that is different. Lordship has not.
Madam, when this sale will take place?
3rd September, my lord.
At September.
Yes,
All right. So
published it 1st of August. Against this only I came.
All right. So I will hear it Monday. I'm fixing it.
My lord, Monday I have some
Monday, my lord.
difficulty, my lord. Kindly make it Tuesday because I'm in my.
Tuesday কত তারিখ?
Orders টা কবে ফাঁকা আছে দেখুন তো কোন দিন ফাঁকা
Tuesday এই ওটা difficult.
ফেরত দিয়ে দিন অরিজিনাল ওনার কাছে
No, lordship can keep it also. This I have a copy. Wednesday হবে? What?
Orders হবে না মানে উনি তো সাবমিশন করেন
My submission is not.
Yes, yes. Let him submit, my lord. I am to meet her.
4টার সময় দেখুন কবে আছে
4টার সময় তো হবে না। Then it won't be taken at 3:30.
Why? Says
3:30 will be there. One midweek, one Friday.
No, may not be in Friday. মঙ্গলবার কোন মঙ্গলবার 5 তারিখ তো এর পরে তারপরে একটা দেখুন 5 তারিখের পরে
ঠিক আছে এফেক্ট তো দেবে না বলছি তো
ওটা তো মান্থলি লিস্টের পরের দিন মুশকিল আছে Mr. Banerjee, no fracture.
Fracture. Otherwise, my lord, I would have been happy.
This why
Fracture in the wrist. That is why I have 2 steel rods on both sides.
14th. তার আগে নেই
Kindly make it prior to that. Otherwise,
every day 4 p.m. is fixed. That is why.
14th at 2 p.m. my lord.
2 p.m. Mr. Banerjee.
Then, my lord.
14th fixed আছে 14th 4 p.m.
4 p.m.
4 p.m. every day matters are being taken up. Who says the
No,
matters?
I'm saying, but if there is a resolution, that is
That
my
is
lord.
up to you.
But still, then we'll do it.
Every day.
We'll do it.
14th কি বার? 14th কিন্তু
Yes, maybe
বৃহস্পতিবার।
because we will be closing for the long holiday, my lord. Every possibility.
তারপরের দিন 15ই আগস্ট আছে তো তাহলে
Any date earlier than that.
earlier is fixed. That is why all days. Because Mr. Mitra has taken 18. That is the first available day on 4 p.m. 19th. After because Mr. Mitra has taken 18. That is the first day. Others.
Then Lordship will fix it up on which date, my lord?
19th.
19th. But 19th, achi.
19th, sir, is not.
19th তো বললাম তো Mr. Mitra's matter. 19th.
But 19th, there is some difficulty I have, my lord. 19th.
Very 20th?
Yes.
20 তারিখ?
20th, it's
আসুন
4 p.m. 4 p.m.
4 p.m. Due to paucity of time, this matter could not be taken.
My lord, bank has.
Which matter?
My lord, I have mentioned Wednesday. My lord kept it on Saturday, but since it is not running in the list, the matter is not coming. I heard from my clerk. So, my lord.
I could not follow. What are you saying?
My lord, I mentioned this matter on Wednesday.
Yes.
Your lordship.
Wednesday means 2nd of August. I have fixed all matters.
My lord, but it is not. My clerk told since this matter is not running in the list, it will not come in the list.
No, it is the new matter.
My lord.
It is not appearing in the list.
My lord, I have prepared the application. It is not running in the list. My lord, what happened to that? My bank account is freezed. Bank is.
Sir, where is the matter? Only I have said upgraded matters from the list.
Yes, madam. My lord, kindly, my lord, this is the last chance of mine.
What?
On 4th, my application will be dismissed before DRA. Kindly, Harshdeep.
Where is that matter lying? The file is not here.
My lord,
File is not here.
My lord, kindly, my lord. My lord,
Sir, unless the file is here, how can it be brought?
my lord, kindly do direct the
To cannot be done, sir. Today is Friday. 3:45. Tomorrow is
mentioned before. Kindly, my lord.
Sir, only I have asked you those for upgradation of those, but you could have mentioned it earlier.
My lord, I have told, but I could not submit, my lord.
Why?
My lord, kindly, my lord, kindly.
Sir, unless the file comes, it cannot be done. Cannot be helped.
My lord,
I have accepted all the slips which matters are in the list.
Lord, clerk told file is here.
File is here.
Yes, my lord.
If the file is here, it will be kept.